We're live, Mr. Chairman.
Okay, committee, let's come back to order. Just a couple of housekeeping items. It's on the chairman that we ran a little bit past on the agenda this morning, so thank you for your patience. To those of you who had to wait over the lunch hour for us to get back underway, we want to follow up on issues that were brought up at our first meeting, and we will do that with our chiefs of police and perhaps our district attorney. If you guys wanted to come up and be ready to kind of catch us up on a couple of things, that'd be great. And then we'll take up the statutory right of appeal. And we'll try to stay on point this afternoon, committee, and get us through at a reasonable hour. So thank you. Welcome back, gentlemen, to the microphone. Please take it away. Let's start with you, Mr. Thompson. Thank you.
Thank you, Mr. Chairman. My name is Alan Thompson, Executive Director of WASCOP, Chiefs and Sheriffs Association. You'll see that there is some documentation we provided based on some questions from the Judiciary's last meeting about some proposed law changes. And basically on that first page, it indicates that the biggest item out of those proposed law changes that were of interest to those that responded to our poll were around strengthening laws around squatting on property owned by others and expanding the laws around fraudulent leases. I think the discussion this morning helps get us in that direction, and we look forward to being part of that discussion going forward. Second and third on that list was strengthening the vehicle theft laws and limiting the scope of unauthorized use of a motor vehicle. We don't, I guess to explain that concept, the theft statute would appear to apply anytime someone takes a vehicle belonging to another person. But we have a misdemeanor under the traffic components that is at 3111 something, 31.7, 111. Okay. Okay. That makes it a misdemeanor when you take a vehicle of another person unauthorized, and limiting the scope of that to certain instances where the vehicle didn't travel very far, no damage to the vehicle, the owner wasn't prohibited from using the vehicle at the time that they needed to or something like that, I think are of interest to law enforcement. And then kind of squaring up the penalty portion of aggravated battery and felony eluding. It'd be more advantageous to prosecute aggravated battery when there's an eluding case and injury to an officer or the general public, because the penalties are quite different. So those were the top three, and then the specific questions asked to them are all in those documents that are provided to you. And just to be brief, I think it reads for itself, so I'd be happy to answer any questions, Mr. Chairman.
Thank you, Mr. Thompson. Any questions or thoughts for the sheriffs and chiefs of police? Okay. Mr. Co-Chairman.
I noticed on some of those surveys, some of your members did not support. Did they offer any explanation of why they weren't supporting some of those?
Mr. Thompson?
Yeah, Mr. Chairman, to answer that question, there wasn't an opportunity to comment on there, but there was in some, like if you look, I want to say it, question 7 of 11. There was other questions that had to do with not this committee's work, and one of those I think had a free text area, but I haven't been advised of why anybody would oppose any of those questions.
So I've got a question. The vehicle theft laws, real quickly, what's some of the reasoning? And I know there are members of this panel that don't necessarily support strengthening that, but it's hard for some of my constituents to know that virtually nothing's going to happen to somebody if they take a car. What's the sheriffs and chiefs of police, what's that 50%? What's the reaction generally? Have you heard on the street? Have any of them talked to you about this is why we don't think it ought to be strengthened? That seems
No,
just- Seems like a low number, yeah.
Yeah, Mr. Chairman, I'm trying to find that specific one. I thought it was higher than that. Yeah, so would you support strengthening vehicle theft laws and limiting the scope of the misdemeanor unauthorized use of a motor vehicle? Of the 28 respondents, almost 80% of them, 78.57%, thought yes, and 2 of those thought no. They thought the misdemeanor existing law was efficient enough or good enough for what they need. Now, as I read the theft statute, I believe it can absolutely be applied because you're depriving an owner of their property. But I wouldn't leave it to maybe the attorneys to mention how that applies in the law, because it would seem like if you charge someone with a felony and they would ask a judge or ask the prosecutor that they were more in line to be prosecuted with the misdemeanor case. I just think that maybe putting some, I don't know, road guides on that, or, limits on the misdemeanor application of that to those instances where, it would be more appropriate.
Thank you. All right, so let's go to Representative Oakley.
Thank you, Mr. Chairman. Just to continue that discussion, thank you. I was wondering, and maybe you already said this and I apologize, but who was it that wrote these questions? Because I think the premise of this question is misleading, if not incorrect, for the reasons that, ironically, I think that you said, which is there is a felony and there is a misdemeanor. My understanding is there has been some proposition to basically get rid of the misdemeanor, which I think would not be the correct course of action. However, that's not what this question asks. It just says, would you support strengthening laws? Well, I mean, I think if you ask that form of a question to law enforcement, you're probably going to get the answer yes, which is what you did here, right? You got the answers, but I don't understand the premise of this question saying, so strengthening theft laws, but limiting unauthorized. How would that even be done? Like, what does this question mean? Do you know?
Mr. Chairman, Representative Oakley, so yes, I would agree that the question is leading and worded poorly based on the application of existing theft laws. The questions were generated based on the discussion at the last meeting, and I don't remember the particulars of that discussion, but getting that discussion out there, I guess, on unauthorized use versus application of the theft statute. And it would be better asked, what are we prosecuting the theft statute across the state? What I'm hearing is mostly that those charges are filed, but they're dropped to a misdemeanor unauthorized use in the conviction process down the road. That's anecdotal. I don't have data on it. That's just the concerns that have been raised with me. So I would say that it wouldn't be strengthening the laws, but the use of the existing laws or limiting the scope of the unauthorized use of a motor vehicle.
Thank you, Representative. Anything else for the sheriff? Let's go to the district attorney. Mr. Edson, welcome back. Thank you for your patience and sticking around a little bit.
Thank you, Mr. Chairman, Co-Chairman, members of the committee. My name's Dan Edson, and I am the district attorney in Casper. In June, when I had the opportunity to speak before you, I talked a little bit about resources allocated to the district attorney's office or the prosecutor's office in general. I'm kind of back with that same outlook. As I prepared for my remarks today, it hit me that we have a whole cottage industry now that prosecutors take care of. Perhaps in the old days, prosecutors were often thought of as people enforcing the law, and that's what we've talked about a lot here today. But we do a lot more than that. On our plate nowadays is sex offender registry. Should people be allowed to get off the sex offender registry? What that means for my office is I'm dedicating someone to answer those petitions, go to court to handle those things. relief from interlock requirements. We are flooded with those two items, and that takes yet another person in my office. Expungements of criminal convictions. Things that the prosecutor, when you think of a prosecutor, you may not think of those ancillary duties that we have, but we surely do have those. I heard a line yesterday that the criminal justice system is the ER for society's ills. And I think that might be true. And a little bit along that line, I'm here to say, we're kind of running out of doctors to treat. We handle those things, we handle drug court in Natrona County. It's a very important program. We have great success. But when you think of those things, that's not the traditional role of the prosecutor. We handle student court now. Help kids that get in trouble, try to graduate from high school and do so without a criminal conviction on their record. We handle single point of entry for juvenile cases to figure out where they go. And soon we're going to handle what's termed as mental court or adult diversion. It was a rollout program, as I understand, in Campbell County, and it's going to start in Natrona County in November. We also do a youth diversion program to try to help kids before they get to court. All those things are things that we don't think the prosecutor, when you think of the role of the prosecutor, those don't come to mind. In my 24 years in the office, those roles have expanded over time. But we have yet to get an increase in employees. I think in 2004, we got 2 prosecutors. And that was the last time in 24 years we've seen an increase in prosecutors in the office. I can tell you with specialty courts now, drug court, student court, those courts, that pretty much takes care of one prosecutor almost full-time. He can't handle a full-time caseload and those things. You couple that with discovery, and we've talked about discovery a little bit, and my friends that are attorneys understand this. Discovery is large, perhaps the largest that we've ever seen. Every police officer has body cam, dash cam, cage cam. They all have photographs. All that's electronically sent. The nice part is the electronic portion. The downside is, at times, getting computers and things to talk to one another and verifying that you have all this discovery. Right now in Natrona County, we probably have 2 of the most high-profile murder cases in the state, involving 25, 30 officers per case. If you could imagine just the body cam and making sure you have those things, making sure those things from cage cams and reports are done, and doing all this other ancillary work as well. In Natrona County, in the district court, discovery has to be sent 30 days after district court arraignment. That can be extremely quick. At times, our docket in Natrona County moves quick. From arraignment to trial at times is less than 60 days. That's extraordinary. In the larger cases, they do take time. There's more complexity, more moving parts, but it still takes manpower to cover all this. You couple that with our caseload, and the last time I was here, Representative Oakley and I kind of bantered back and forth who had the heavier caseload. The truth of the matter is, we average on the felony side somewhere between 360 felonies and 420 a year. We do that with 4 attorneys, plus myself. On my misdemeanor side, without traffic, just cases that we open. In traffic, you still have to show up and handle traffic court. We're somewhere north of 3,000 misdemeanor cases. We do that with 3 attorneys. I have 1 juvenile attorney that handles about 167 juveniles a year, and then support staff for the attorneys. at some point, you feel much like the Dutch boy with his fingers in the dam, and you're kind of running out of fingers. And as we expand things and do things, at some point, we will need to address, the allocation to the prosecutor's office. And to that end, I have submitted a supplemental budget request to add some prosecutors and one support staff person. But I thought it was important to address this committee and explain kind of what's going on. 'Cause sometimes the role of the prosecutor, to borrow a line I heard today, can run pretty deep once you step off that bank. The water's deep. With that, I would be happy to stand for any questions.
So, Mr. Eidson, can you do me a favor? Because it's something that it took me a while to become aware of, this separation between the county attorneys and a district attorney. Can you help everybody once again to understand that setup?
Yes, sir, Mr. Chairman. In the 80s, there was a movement to move to the district attorney model. If counties had, I believe, over 50,000 residents in it. I may be off on that number a little bit. And the counties wanted to do that. There were 2 counties that met those requirements, Laramie and Natrona County. So the district attorney's office in both counties were started. The county attorney handles all legal issues for the county. They do not prosecute cases. The district attorney's office will prosecute all misdemeanor and felony cases within the district. There are some that go to city courts and things like that, but the bulk majority fall within the district attorney's office. With respect to the county attorney's office, they are also dealing with mental health, Title 25 civil commitments, and those type of things. That's a rough thumbnail version of the split of the 2 offices.
So those line items come up through our budget differently. And I think that has been the challenge, Mr. District Attorney. It just is what it is. Those line items would support Cheyenne and Casper because they're the only ones with district attorneys, correct? To this day, right?
That is correct, sir.
Yeah. So, thank you. Mr. Co-Chairman?
Thank you, Mr. Chairman. Mr. District Attorney, we talked a while back, and I think you mentioned to me something about limitations at the state crime lab with regards to confirmatory tests on fentanyl and the impact that has on your office.
Yes.
Could you share that with the rest of the committee, please?
Sure. Mr. Chairman, Co-Chairman, when we deal with any type of drug, it gets sent to the Wyoming State Crime Lab for testing. Obviously, there's 2 tests that are performed. One's a presumptive positive test. That in of itself doesn't carry a lot of legal significance in a courtroom, so those tests are confirmed. One of those being fentanyl. We've talked a little bit about fentanyl today. Fentanyl is an extreme issue in all our counties. We are seeing thousands of pills, overdoses weekly in Natrona County, and those are not exaggerations by any means. But we need to be able to get our fentanyl confirmed. And we continue to work on that with the lab in setting up processes to get there. We're not there yet. So that's an extreme limitation of what we can do with respect to folks with possession of fentanyl. The other thing is how quickly we can get our test results back from the lab, given our discovery requirements in Natrona County. And at times, those can be extremely challenging. And that's not to throw stones at the lab by any means. I think they're doing a great job. It's just kind of the realities of where we sit here today.
So, follow up, Mr. Co-Chairman.
So when the state lab is unable to perform a confirmatory test and you want to prosecute a case involving fentanyl, what happens next and what's the impact on costs associated with that?
Yes, sir. Mr. Chairman, co-chairman, a couple of things happen potentially. Perhaps you work out a negotiated disposition. I think that's where you start to try to resolve this. If that's something that's unattainable for whatever reason, you look at asking for a continuance from the court, talking with the crime lab, seeing where else can we get confirmatory testing, those type of things. They do carry associated costs. I can't tell you the dollar figure on that. But those are the things that go through the prosecutor's mind. And to be frank, at times, you have to make a decision as that prosecutor. Do I take a little less than I should on a negotiated disposition, knowing that I have this issue sitting here and hoping we can obtain justice by doing that?
Go ahead.
So if you want to take this case to trial, you have to send that fentanyl to another lab out of state to analyze, if I understand it right.
Yes, sir.
And then if you were going to use that evidence in court, you would have to bring an expert from that laboratory out of state back to Wyoming to testify at that trial. Who pays those costs?
Mr. Chairman, co-chairman, with respect to expert fees, our office would pay those. With respect to travel, the clerk of district court would pick up those costs for, in this case, Natrona County. The testing costs, I don't, that's a part I don't know about.
Anything else, committee? Anything else for the district attorney? We will look forward to the discussions ahead regarding the budget. And you indicated, Mr. Itzen, that you have submitted a supplemental budget request that will go to the governor. Did I understand that correctly?
Yes, sir, I have.
Okay. I'm assuming that the district attorney here faces the same things that you're facing up in the center part of the state.
Mr. Chairman, Mr. Co-Chairman, I would agree with that.
Okay.
I think they're busier than we are, if you look at their numbers. The old saying, and I think it's still fairly accurate, between the two district attorneys' offices, we handle about 66% of the crime in the state of Wyoming.
Thank you. That's good to know.
Yes, sir.
Appreciate both of you. Thank you. I don't know if, since this was follow-up information, if there's any public comment, we would sure entertain that. If there's anyone wants to provide any public comment. Okay, thank you, gentlemen. We're going to move on to the statutory right of appeal, and the consideration of LSO 128, the state's right of appeal in criminal cases. Mr. Fuller, can you do us a favor and walk us through this bill draft, please?
Yes, Mr. Chairman. So 25 LSO 128 0.4, this is 3-01 in the meeting materials. This is a draft the committee requested in June after testimony and a presentation from the Attorney General's office. And this bill draft would authorize the state to appeal from certain orders or judgments that are entered in criminal cases that are adverse to the state, to the prosecution, that is. The direction at the June meeting was to kind of start with what Utah has done, and that is the language that's on pages 2 through 4. And then the staff comments just provides kind of an alternate framework based on Maine's current law and then Texas's law. So starting on page 2, this would be a new section of statute that just provides that the state may, as a matter of right, appeal from the following orders and judgments, and then the rest of the language lists those orders. So first, a final judgment of dismissal of an indictment or information or any count, including the dismissal of a felony information and following a decision not to bind a defendant over for trial to district court. Page 2, line 9, a pretrial order that dismisses a charge on the ground that the court's suppression of evidence has substantially impaired the state's case. And then for this particular order, if an appeal is made, the matter is stayed. Next, an order granting a motion to withdraw a guilty plea or a no contest plea. An order arresting or modifying a judgment of conviction. An order terminating the prosecution because of a finding of double jeopardy or the denial of a speedy trial. Then moving on to page 3, an order granting a new trial. An order that holds a statute or any part of a statute invalid. Page 3, line 7, an order that adjudicates a defendant as incompetent or that has a mental illness or deficiency that would make the defendant unfit to proceed. Next, an order that adjudicates that a defendant lacks the requisite mental capacity for execution of the defendant under 713-902. Next, an order that finds that a sentence is illegal or an order correcting an illegal sentence. And then finally, an order dismissing a charge under 62602, which is the dismissal on self-defense grounds. Then on page 3, line 23, so in addition to all of those specific orders and judgments that the state may appeal, subsection B is kind of a catch-all. So the state may seek discretionary appellate review of any interlocutory order entered before jeopardy attaches. So it's a little different in that for any order that's not listed in subsection A, the state can seek an appeal, but it is discretionary, and it has to be an order that was entered before jeopardy attaches. Generally what that means for a jury trial is any order entered before the jury is impaneled. For a bench trial, generally it's when evidence is started to be presented and taken by the court. Then, Mr. Chairman, on page 4, starting line 16, is a similar version for Maine. And it's structured a little differently, similar language, but slightly different. So the Maine statute says that an appeal may be taken by the state for an order that suppresses any evidence, an order that prevents the state from obtaining evidence, a pretrial dismissal of an indictment, information, or complaint, and then any other order of the court that's made before trial that has a reasonable likelihood of causing either serious impairment to or termination of the prosecution. Subsection B, so this is page 4, line 37, kind of splits it out, the next grouping of orders that are based kind of after trial or after a jury verdict. So it'd be an appeal that can be taken from the granting of a motion for a new trial, an arrest of judgment, dismissal, or other orders that would require a new trial or that would result in the termination of the prosecution in favor of the defendant, if permitted by the double jeopardy provisions of the federal and state constitutions. Page 5, line 11 would be an appeal may be taken by the state for sentence corrections or reductions. The bolded part are just some notes for the committee to consider. Maine statute included some other provisions as well. So first, Maine requires a written approval of the Attorney General before an appeal is taken. The Maine language also says that the provisions of that section shall be liberally construed to effectuate its purpose. And then it also expressly provides that, rulemaking for the Supreme Court. Next is Texas's version. And starting on page 5, line 35, are just a list of the orders, many of which are similar. The arrest of a judgment, dismissal of an indictment, granting of a new trial, dismissal for double jeopardy. On the top of page 6, granting of a motion to suppress evidence. Here, there's a little more language about jeopardy having not attached, and then the state has to certify, this is a little different, to the trial court that the appeal is not taken for the purpose of delay and that the evidence that was suppressed is of substantial importance in the case. Texas also provides a right of appeal under their state's Post-Conviction Act. Wyoming law already provides this in 712-407. Next, page 6, line 13, the state can appeal a sentence on the ground that it is illegal. The state can appeal a ruling on a question of law if the defendant is convicted and appeals. And then the state is entitled to a stay in the proceedings pending the disposition of any appeal that it brings. The state is also entitled to appeal an order that terminates the duty to register as a sex offender. So that's a little different under Texas's law compared to the other states. The bolded language on page 6 are just other considerations that Texas's law contains that the other states didn't. So Texas statute expressly requires an appeal to be taken within 20 days of the applicable order or judgment. It also tells the Supreme Court to give precedence to an appeal that's brought under this section. Texas law specifies the conditions under which a defendant may remain on bail pending the state's appeal. They provide that the rules of appellate procedure apply, and Texas also has language that says nothing affects a defendant's right to appeal. So those are just considerations there. Mr. Chairman, with that, I would stand for questions.
Thank you, Mr. Fuller. Nice work again. Appreciate the inclusion of the options that you found in some of the other states. So any questions for Mr. Fuller regarding the drafting? Representative Provenza.
Thank you, Mr. Chairman. Mr. Fuller, I think you said this, but I just want to make sure we're clear. Can the, so since we don't have an appellate court per se, can the Supreme Court use discretion on what cases they take, or can they reject some of these appeals?
Mr. Fuller?
Yep. So Mr. Chairman, Representative Provenza, under current law, everything with our Supreme Court is discretionary. With this language, so just taking the Utah version, for example, the state may, as a matter of right, the court would have, I mean, that would be an appeal the court would have to hear.
Any other questions on the drafter? Okay, thank you very much, Mr. Fuller. We reserve the right to ask you a question later. Would the Office of the Attorney General like to come forward? And thank you very much for your patience. That was on me that we held over the lunch hour. Thank you for being here. Please introduce yourself and for the record.
Thank you, Mr. Chairman, members of the committee. My name is Jenny Craig. I am the Deputy Attorney General of the Criminal Division at the Wyoming Attorney General's Office. And I would just like to thank you for giving me the opportunity to be here today to talk with you about this draft bill. Just as a reminder, this was an interim topic that was brought to the committee's attention by the Attorney General. This is an important topic to the Attorney General's office. And in speaking with the county attorneys and district attorneys throughout the state, this is a very important topic for them as well. And so we appreciate the opportunity to be able to discuss this with you. The Attorney General and I have looked closely at the draft bill. We understand the language that's in the draft bill. We think that the language in the draft bill is workable. Importantly, the draft bill takes into consideration, as we discussed at the last committee meeting, that double jeopardy is always going to be the sideboards on what types of orders the state is going to be able to appeal. The state will never be able to appeal everything in a criminal case like a defendant can because of that issue of double jeopardy. And the language in the draft bill from the Utah statute does that just fine. There are no problems with double jeopardy there. I'd also like to point out that I find the draft language helpful in the sense that it identifies exactly what types of orders can be appealed. It's not leaving sort of these questions out there of, well, maybe we can appeal, say, a 404B issue. Some of the prosecutors on the panel know what I'm referring to with that. That's something that comes up a lot in criminal cases, but those types of orders are not listed in here. So it makes it clear what types of orders can be appealed. And while it's limited to these types of orders, it does capture the important orders that I think do need to be reviewed at times coming out of the trial courts. And those are the orders that are essentially going to end the prosecution. They're dismissing the case. They're dismissing the state's ability to continue moving forward with those prosecutions. And the other orders that are listed are ones that are doing something with a conviction after the state has been able to get a conviction either through a guilty plea or through a conviction at trial. And so those are the important issues, and those are contained in here, even though the types of orders are limited. And I think that the limitation on the types of orders are also important when we think about using, what state resources do we have to be able to put forward on this? This is something that's new. The state doesn't get to appeal anything right now. And so by adopting a statute like this, it's certainly going to put more work on the executive and the judicial branches to the extent that the statute is used. But by limiting the types of orders that can be appealed, we are recognizing there are limitations to those resources that can be used. And I think that it also is putting in the hands of the prosecutors. We just heard from Mr. Itzen about the resources that are available in those offices. And the district attorney's offices or the county attorney's offices are going to be the ones that are going to make the decisions on whether they have the resources available to move forward with these appeals. But it at least gives them the opportunity to do so when they feel like the evidence that has been suppressed in those cases or the decisions that have been made that are ending their prosecutions are significant enough to move forward in those matters. And so I think that this draft language does a good job of keeping those items in mind. And the last thing that I'd just like to point out is this draft language also doesn't cause me any concerns with the idea of a speedy trial. I think that speedy trial is something that might pop into people's minds. Are we creating a problem by allowing the state to appeal something that's happening before jeopardy attaches, which, as Mr. Fuller pointed out, is generally before the jury is impaneled. But I would just like to identify again that most of these orders that are listed in the proposed language are orders that are already ending the prosecution. And so we don't have an issue necessarily where this person is sitting there waiting to go to trial because there's charges pending. Instead, what these orders have generally done is they've ended that prosecution. So with that being said, I'll stand for any questions that you might have.
Ms. Craig, thank you very much. Representative Oakley?
Thank you, Mr. Chairman. My question, it has to do with the possible addition of discretionary type. So we heard from Mr. Fuller that as written, it's kind of as a matter of right. When you said 404B, I perked up a little. And I was wondering if you would support the inclusion of possible additional types of orders that could be appealed, but maybe under a discretionary. I think all of these are a matter of right, but if we had things that we wanted to discuss, such as a 404B, but do those as a discretionary type of appeal, if you've thought about that, if you'd support that, I'm just kind of thinking through it. That hadn't entered my mind until we had this discussion. So any thoughts on that?
Deputy Craig, go ahead.
Thank you, Mr. Chairman. Representative Oakley. I mean, in a perfect world, I'm open to the state being able to appeal any adverse ruling, but I also understand our justice system and the limitations put on that. Now, that being said, this draft language that is currently here, that's drafted from the Utah statute, would allow those types of discretionary appeals because, as it noted, the state would have the ability to seek discretionary review on any other order that doesn't implicate double jeopardy. And so your 404B orders would certainly fall into that. Now, there are other states that will specifically list what types of orders they can seek discretionary review on, and so that could be something that we would look at. But for purposes of what we're hoping to accomplish here, my focus would be on what the state would have the right to appeal, but I would certainly be open to discussion about discretionary review being sought on other orders.
Representative Provenza?
Thank you, Mr. Chairman. I guess one of my questions would be, who represents the client or the defendant on appeal? So if you're appealing a suppression of evidence, are we relying on potentially the public defender's office? And have you had conversations with the public defender's office to understand what that increased workload could look like?
Ms. Craig, go ahead.
Mr. Chairman, Representative Provenza, if the defendant is represented by the Public Defender's Office during the regular trial proceedings, I would presume that they would be represented by the Public Defender's Office on appeal. And if the defendant is being represented by a private attorney, then I would assume that that would be the case going forward as well there. I haven't had any discussions with the Public Defender's Office about that specifically. My anticipation would be, while this mechanism I believe is important for the state to be able to utilize, I don't really see it being used incredibly often. I think that, and part of that is because of the other resources. The executive branch is going to have to, the DAs, the county attorneys, my office is going to have to make a decision of whether we have the resources at that moment to be able to handle doing an appeal. Is this order important enough? Is this case, I hate to say important enough because every case is important in its own way. But those are decisions that are going to have to be made. So, but to answer your question more succinctly, no, I have not had those conversations.
Representative Chestic, and then we'll go to Representative Harrelson.
Thank you, Mr. Chairman and Deputy Craig. Kind of following up on Representative Oakley's question about maybe adding some discretionary review here. Another way to get at this, trying to balance the unequal state of affairs between the well-funded prosecution's office versus the underfunded defender office. Another way to get at that might be to, at least for some of these categories, there's 11 things in this list, maybe not all of them, but for some of them, what would be your thought about having an increased or heightened standard of review to tell the Supreme Court that you can grant relief only if there's compelling evidence or some other heightened standard of review to try and address the imbalance between the prosecution and the defense?
Thoughts on that, Ms. Craig?
Mr. Chairman, Representative Chestic, I guess I'm not exactly sure that I understand from what perspective you're coming with from that question. When we talk about a heightened standard of review, the court will generally, they will apply that standard of review once the case is actually before it and how they're going to analyze that claim. And right now, the state can't get into the Supreme Court, and so no standard of review is being applied. So from that perspective, I'm not sure a heightened standard of review would help because it doesn't get us in the door. Now, if you're talking about it from the perspective of perhaps you would create legislation that would, because right now the problem is that the Supreme Court has interpreted their basically inherent authority as a court to grant discretionary review so incredibly limited when it comes to when the state is requesting that discretionary review, it almost amounts to not being able to have any review at all. And so if you're looking at it from the perspective that perhaps the legislative body would create a statute that would make sure that the court knows, oh, when you're considering discretionary review, you should consider some other factors other than the few limited ones that you're considering already, then perhaps that would be helpful. But our experience with discretionary review at this point, with the way that the court has interpreted their authorities, the state has no remedy at all.
Representative Harrelson.
Thank you, Mr. Chairman. Thank you for coming out and having this conversation today about this topic. Couple concerns that I have. One, it feels a little bit like we could weaponize a really large pocketbook against the citizens of the state. That's obviously worst case scenario, but I could see that. I mean, I could see it being kind of a two bites on the apple type situation here. Can you talk about that? So let's say a case goes through, the state has a ruling that goes in the favor of a citizen, and then there's a repeal that comes back in. Could you just talk towards that?
Ms. Craig?
Mr. Chairman, Representative Harrelson, I want to make something abundantly clear with what we are asking for and what this particular draft statute would not do, which is that because I think that there is some concern, and you say the second bite of the apple. The state is not asking for a second bite at the apple. The state is asking for a fair shot at its first bite of the apple. So if we are in a situation where we have gone to trial and the citizen gets a favorable result. The citizen is exonerated of the criminal charges. They're acquitted. Jeopardy has attached. The state cannot seek review of that decision. Instead, the state is seeking review of decisions that are happening before that trial occurs, where perhaps the trial court has made a decision that this evidence was unlawfully seized. That evidence is very important to the state's case. In a lot of, especially in controlled substances cases, that's all of the evidence that the state has. But without some sort of remedy like this, the state is left to just have to deal with that decision, no matter how legally incorrect it might have been. And so all the state is asking for is a mechanism to be able to know that it can go forward through the criminal justice process to a trial and being able to use the evidence that it lawfully obtained. It's not seeking a second bite at the apple.
Mr. Co-Chairman.
Thank you, Mr. Chairman. So when we look, I think your testimony is that the Utah language is very workable, but I was wondering the Maine and Texas language, do either of those offer language which would be, from your vantage point, preferable or desirable for us to consider?
Mr. Chairman, Mr. Co-Chairman, I believe that the Utah language is workable. I'm not one that's going to let perfection get in the way of a good idea. And so I will say that if I had my druthers about it, language that is in the Maine statute and the Texas statute that would be different from the Utah statute, that I believe is more preferable from the Maine statute or the Texas statute, is when it comes to the suppression motions. In the Utah language, the suppression motion, you're not actually appealing from the order suppressing the evidence. Instead, you're appealing from the dismissal of the charge because you cannot go forward anymore with your prosecution because of the suppression of the evidence. The Maine and the Texas statutes simply say that you can appeal from the suppression order. And so those statutes seem to require one less action. Those statutes don't seem to require the state to actually dismiss something before they can appeal it. Now, I think that there's positives for having a dismissal like that. I think that that's going to make the state think long and hard about, is this evidence something that I really need to go forward with my prosecution, or can I continue going forward with the other evidence that I have? And will perhaps make sure that only the most important suppression issues are being brought on appeal. But, on the other side of that, I'm not sure that the state should necessarily be penalized from being able to use significant evidence just because they have other evidence as well. That's going against the truth-seeking process of the criminal justice system and what the exclusionary rule is intended for. But that would really be the only one that I think is worth mentioning.
Representative Jennings, do you have a question?
Well, thank you, Mr.
Take it away.
Chairman.
Yes.
I do have a question. So I have actually kind of two questions for you. Could you put one of these in layman terms where, for those of us that aren't legal or lawyers, put it in layman terms of something that happened in an actual case that you looked at this and you said, wow, this is a real bad miscarriage of justice just because somebody dismissed this too early, or could you give us something that's really going to show us the problem in layman terms? And then I guess the second one would be, why do you think our founders didn't grant this at the beginning? They certainly understood about the judiciary, right? And could there have been a reason that they didn't go down this road? And why are we just now hearing about this being this kind of a problem?
Mr. Chairman.
Go ahead.
Representative Jennings. To start with your first question, to give you a real-world example. A real-world example that we see with some regularity, and I'll give a controlled substance case, but then because those are the ones we see most often. The whole criminal conduct comes from the fact that the police found controlled substances in the trunk of a vehicle. And then the defendant moves to suppress that evidence, claiming that there was a Fourth Amendment right. Perhaps it was because the trooper asked too many questions during the traffic stop that weren't related to the reason for the traffic stop. And the judge decides to suppress that evidence. But the judge decides to suppress that evidence based on a reason that's not clearly, it's clearly contrary to the law. And so the state no longer has that evidence of the trunk full of controlled substances to use against the defendant, and they can no longer further their prosecution, even though the trial judge's decision on that suppression was incorrect. It was lawfully incorrect. So that's a real world example. But to give you maybe a more serious example, we had a case, and so this deals with more with a competency and dismissal issue. There was a man that was charged with first-degree murder. It was a gruesome, horrific murder. And there were some issues regarding his competency that arose. And the trial judge decided that this man wasn't competent to proceed. And so there becomes this question of, well, what do we do with the prosecution at that point if he can't proceed? And I think that there were actually some real issues with whether that decision about whether he was competent or not was accurate. But beyond that, the prosecutor moved to go ahead and dismiss the prosecution because he wasn't competent to proceed, and asked to dismiss it without prejudice, which is significant because dismissing something without prejudice means that you can later bring the prosecution again. So if this man became competent, we could go ahead and prosecute him. But this particular judge refused to sign the dismissal order unless it was with prejudice, meaning that the state could never charge this man with first-degree murder again, even if next week he became completely competent. That was a pretty serious miscarriage of justice in my mind, and the state had no ability to seek review of those decisions because they didn't fit with the Supreme Court's discretionary review outline. So those are a couple of real-world examples. Something might be as minor as a controlled substance, but we've had significant decisions made that ended prosecutions in very serious murder cases as well. To answer your second question about why didn't the founders think of this, I think that back in the day, it was pretty common that there was this idea that appeals are of final orders, meaning the case is done. And there was this idea that if a case is done and the defendant won, well, you can't do anything about that because we have this idea of double jeopardy. And that still is the case today. But over time, I think that the law has developed in such a way that it became more acknowledging that, well, that doesn't mean that we can't take care of problems before jeopardy has attached. And so I think that there was more of a move in the 70s and 80s where a lot of these states started establishing these statutes, giving states the ability to have certain orders reviewed. Now, why didn't we do it? I'm not 100% sure, but I can say that during the 80s, the Wyoming Supreme Court started acknowledging that they had their own inherent authority to consider some of these issues as they were raised by the state. Now, the Supreme Court acknowledged that the state shouldn't be able to just bring every single thing, and so it indicated that it would only review these important issues, and they would talk about things being constitutional in nature or issues of first impression or of great public importance. But the state was able to get its foot in the door through discretionary review, not every time they wanted to, but occasionally. But in January, the Supreme Court really buckled down on their view on that and said that not only would they not review, but that it was error for a district court to review a decision from the circuit court that they acknowledged was incorrect, but because it didn't meet these guidelines that they have, that it was error for that court to review it. And so that's why it's coming to your attention now. While we had what we believed was at least some remedy, we now have none.
Okay, anything else for the Deputy Attorney
Follow up.
General? Sure, go ahead, Mr.
Follow up.
Jennings, then we'll.
So I guess my
then we'll
question would
get
be,
going.
both of
Yeah,
your
great.
cases, as I look at that, just the layman, not a lawyer, not any of the legal, sounds like crummy judges. And so if you look at this, what's being put before us right now, this is really the first bite of the apple for some new legal remedy here, because this won't be the last. I mean, if you get this, then you'll come back and you'll ask for other cases, because there'll be other cases of miscarriage of justice. And so it just seems like that maybe there ought to be other remedies with judges that don't handle their judgeships correctly.
I think there might have been a question in there, don't you think so, or do you disagree, or, whatever. But, yeah.
Mr. Chairman, Representative Jennings, I believe that mistakes are made. And I think that sometimes mistakes are made for perhaps nefarious reasons, but I think honest mistakes are also made. And I think that honest mistakes should also be able to be subject to review, because the purpose of the judicial process and the criminal justice system is for the truth to be considered and for people to be judged by their peers in a court of law. And sometimes mistakes are made. That's why defendants are allowed to appeal, because we know that the judges don't get it right. And sometimes that's due to a very innocent reason. Maybe the law just wasn't very well developed on that particular issue. And that's how law is made. And that's how we get case law and we get to where we are. So while, yes, I agree, there should be remedies for crummy judges, I don't think that that's what we're dealing with most of the time here.
Okay, thank you, Ms. Craig, appreciate it. I want to move to public comment on LSO 128, the state's right of appeal in criminal cases. Ms. Butler, I didn't mean to miss you. You're not necessarily public comment. But
Mr.
anyway,
Chairman,
my
it's no
apologies.
problem at all. Mr. Chairman, my name is Elisa Butler. I'm the State Court Administrator with the Wyoming Judicial Branch. I have brought, no, I have not brought with me today. They have come of their own accord. I have two judges sitting next to me. On my right is Judge Rob Sanford. He's a circuit court judge in Albany County in our 2nd Judicial District. And on my left is Judge Catherine Wilking, who is a district court judge in the 7th Judicial District in Natrona County. I am going to sit back and be quiet because I think these two can tell you much more about the effect that this bill will have on the judiciary than I could.
Thank you, Ms. Butler. Again, my apologies for overlooking. Judge Wilking, welcome. You want to take the ball first and visit with us about this issue?
I would like to do that. Mr. Chairman, Mr. Co-Chairman, and other members of the committee, my name is Catherine Wilking. I'm a district court judge in Natrona County. The judiciary obviously understands this is a policy decision that you're going to make. Historically, this committee in particular has been gracious enough to say, what impact might this have on the judiciary? And so that's what we're here for today, and I appreciate that opportunity. As I was listening to the prior speaker's comments, I thought it was important to make sure everybody understands that there was a lot of talk about the Supreme Court as an appellate court, but as a district court judge, I also sit as an appellate court from circuit court. I'm also the appellate court from municipal courts. In Natrona County, there are 3 municipal courts that I get appeals from. And so this bill that you're discussing, depending on what subsection is used, there are going to be different courts that are the appellate court. So in one of the subsections, the state would have the right to appeal if my fellow judge across the way here, if he decided at a preliminary hearing to not bind over a felony case or a charge, let's say there were multiple charges in a felony case and one of them wasn't bound over, under this bill, the state could then appeal to me as the district court, the circuit court judge's decision. And so then I'm acting as the appellate court. Important to recognize too then that if somebody doesn't like what I decide about what the circuit court did, well, then they're going to appeal it to the Wyoming Supreme Court. And so there are different players that are going to come into action under the proposed statute. There was the mention by Representative Provenza about who represents the defendant in these cases. Right now, when I get a criminal appeal, one instituted by a defendant from the circuit court level, what I'll call the frontline public defender represents that individual on the appeal. So those folks are having to draft briefs and get a record complete. And so the frontline workers are doing that. It's my understanding that the Attorney General's office has made it clear that their office will not be involved in these frontline appeals. So it will be the county attorneys and the district attorneys initiating them. Once a matter is appealed from a district court level to the Supreme Court level, there are agencies within the Attorney General's office, their appellate division handles it, and the state public defender has an appellate division as well. So there could be some handoffs of this responsibility. The new structure, like I said, would provide the ability to appeal something from a circuit court to a district court to the Supreme Court. And one of the things that kind of comes to my mind and the comments that have been made is the impacts on the county and district attorneys' offices would be large if they decide to undertake this work. It would have a lot of work for the public defender's office that's representing these individuals, and a lot of work for the courts. I know you're all weeping about the work that the court would have to do if you passed this. But it will be largely dependent on the discretion that's exercised by the district attorney and the county attorneys. And that's going to vary from county to county across the state. I was visiting with Mr. Itzen recently and mentioned this proposed bill to him, and you just heard him. His comment was, I don't have time. I don't have the manpower to really vigorously pursue these appeals. I don't think there's a public defender in the state that would say, oh yes, I've got a lot of time to do appellate work when I'm a frontline public defender. And I think maybe that's why in the staff comments that were already mentioned, some states have said there's got to be sign off by your AG if you're going to pursue these appeals. I think that's maybe why that language is in that other version. It could have a significant impact on the courts, both at the district court level and at the Supreme Court level. These, as you've just heard, would be very high priority matters, at least from the district court's perspective, especially the way it's set up. If we have a crime that's been charged and the circuit court judge makes a decision, that's appealed by the state and it may be stayed, particularly if it's a suppression issue or if only one count was bound over and the others weren't. So when I see something like that come across my desk, or if I would, my first thought is there are citizens that have been impacted by an alleged crime. And there may be someone who is in jail. There could be an individual in detention as a result of the charge filed by the state. And it takes time for the person that says the judge got it wrong to file a legal brief to get the record of what happened in the lower court to me. And then the other side gets to say, you know, no, judge, I disagree with what the state is doing. And then the courts have to review that, and it takes a considerable amount of time to process in an appeal. At the district court level, we have a staff attorney. In the Supreme Court, they have a little more support as far as their staff attorneys and their research is concerned. We have all of our other duties that we have to address every day. And I will tell you that if we have cases like this, they're probably going to get a higher priority than some of the other matters that I need to attend to. And whether that's domestic relations cases, other things that don't have set timelines, this can be on my plate, but that's going to mean that some other things get pushed off of the plate as far as timeliness is concerned. Some of the questions that I just personally had when I read it, as I mentioned, I'm the appellate court for municipalities in my jurisdiction. I don't know if that's what is contemplated by the word state in the statute. And those municipalities could have city attorneys that want to appeal to the district court. And again, I don't know who's gonna be the one that represents those indigent individuals. It wouldn't be a statewide public defender's office. They would still be entitled to representation. It may be that the municipalities have to foot the bill for that. So that was a question I had. And then the other thing I was hearing as I was listening to Representative Oakley talk about 404B hearings and things like that is kind of a piecemeal prosecution, then appeal, then back to prosecution, then appeal process. Because all of these things are happening at different times in the life of a criminal case. And so at the circuit court level, if there's something that's not bound over, that can be appealed to the district court. It goes through the appeal process. It eventually gets back before me. And then we have a 404B hearing. And the state doesn't like the way that I ruled on that. And then they can appeal that to the Supreme Court. We wait for months, and then maybe it gets kicked back to me. And then that prosecution can maybe finally go forward. As a former prosecutor, these cases do not get better with time. Witnesses become unavailable, memories do fade. But what's more important to me is the people that I was just discussing, citizens that have been impacted by crimes, and then people that may be held in custody on a bond situation. How long are we waiting for resolution for those folks? And so that's a concern. And then just to kind of comment on the prior speaker's example about the individual found unfit to proceed or not guilty by reason of mental illness. That's also within this statute, and that can be appealed by the state. When I read that, I wondered, as the judge, what am I to do with that individual? Normally, if someone's found not guilty by reason of mental illness, they are either committed to the state hospital or some other structures that are put in place in our communities to try to address their needs. I'm unclear what would happen there. And just that whole process, there are evaluators at the state hospital that would come perhaps and say this person is not fit to stand trial or not guilty by reason of mental illness. There's always the opportunity in the statute for the other side to get a second opinion from a different expert. There is a hearing held by the judge, and then a decision is made. So I'm just wondering how that would play out under what's been provided here. Again, recognizing it's a policy decision, but it could have a significant impact on your district courts and certainly your Supreme Court and how people experience the justice system. It's been pretty linear up to now, and I think it could be a little bit disjointed. Thank you, Mr. Chairman.
Thank you, Judge Wilkie. Thanks. Anything for the judge before we go to our other judge? Go ahead, Representative Oakley.
Thank you, Mr. Chairman. And I guess I'm asking permission from the chair. I do have questions. I've got several, but I'm thinking perhaps maybe I can ask both of the judges after Judge Sanford goes. Would that be all right with the chair rather than addressing it now?
Absolutely. To your preference, and we're here to get it right, and we want to work this bill because it is an interim topic, so let's take it away, Judge, and then we'll let the representatives and others on the panel ask any questions they have of you judges.
Co-chairman, thank you so much. Rob Sanford, I'm a circuit court judge in Albany County. I'm also on the Legislative Relations Committee for our judiciary, so I come here carrying the water for other members of the judiciary. I'm brand new to that position, so I don't know many of you. And I look forward to meeting with you and visiting with you and speaking with you both publicly and privately. As the judge mentioned, our role is not to support or oppose proposed legislation. That runs afoul of our ethical guardrails and certainly the separation of powers that we regard very highly. What we do often engage in, and I think we should, is speak truth to power and explain what we think might be the impact on the courts and impact on ultimately your constituents. Judge did a fine job of that. You're probably wondering why a circuit court judge would have any comments at all on an appellate issue, and I'll answer that question. We have no appellate docket in the circuit court, but when I read the legislation, I had a couple thoughts. First of all, I think it's fair to say there does exist today a right of appeal on the part of the state, and as the Attorney General's office mentioned, it is somewhat limited, and that limitation involves the appellate rules, so the Wyoming Rules of Appellate Procedure, and don't ever quote a circuit court judge on appellate rules, but it's somewhere around 13, the Wyoming Rules of Appellate Procedure, and there was a case recently where the Supreme Court did limit that state right of appeal. That case is Larson v. State. That's 24 Wyoming 4. And there was a limitation, but that right of appeal does exist. And I won't dive too deeply into the case, but the long and short of it really is the Supreme Court limited those appeals to matters of great public import. That was sort of the takeaway from that case. So it does exist. How would this change it? How would it affect courts, specifically a circuit court that has no appellate docket? Our concern really has to do with staffing, resources, custody of defendants, or perhaps those who are at the state hospital receiving various evaluations. And if you know this business, you know that sometimes those evaluations take a great deal of time. And if they're contested evaluations, that is dueling experts that opine on the competency of a defendant, those can take great time. Imagine adding on to that the right of appeal on the part of the state. So again, our concern is that of resources and staffing. Think about a defendant that the state believes is dangerous, and let's say rightfully so. And as an evidentiary ruling comes out, a suppression ruling, a 404B ruling that doesn't go in the state's favor, what happens to that defendant while that case is appealed? I know there was talk of, well, first there's a dismissal, and then it may be revisited if remanded back to the lower court. Well, maybe that's the way it goes. Maybe the state does not file that motion to dismiss. Maybe there's more of a main type language in this proposed bill that would be open season on those evidentiary rulings. Our concern is really the life expectancy of a criminal case. And understand, when you're talking to judges that deal with criminal and civil caseloads, as we all do, obviously those criminal cases take precedent over everything else. We have a speedy trial clock. That speedy trial clock is governed partly by rule, but also by constitution. And those are two separate analyses that we must make in determining whether the state met that speedy trial clock. What in the world happens to that speedy trial clock? And I think if you look at just the rule speedy trial issue, it starts at arraignment. That's when the clock starts. So what happens to that speedy trial clock pending appeal? What happens to that defendant who might be in custody or might be released? Maybe that's also the concern. It's, I think, important to note that even at the trial court level, it's very likely to extend the life expectancy of a criminal case because of these appeals. If you look at it, say, from a defense attorney's perspective, and I, like Judge here, am a former prosecutor, but if you look at it from a defense attorney's perspective, the finality that is reached and the calculus of risk that a defense attorney makes when taking a case, or a public defender who didn't pick his or her client, the calculus of risk in reaching certain plea agreements or going to suppression or various avenues, it changes when the only finality that defense attorney and his or her client would get is acquittal at trial. So it changes that calculus from a defense attorney. It also extends, ultimately, very likely, the case at the trial court level. And understand that when that criminal trial docket gets extended, or the life expectancy of a criminal case gets extended, everyone else is at the back of the line. So all those civil cases, all the FE&Ds, everything we talk about, all the things that District Attorney Itzen mentioned, all the things that everyone has to deal with take a back seat to that appellate process. So those are our concerns. And again, we're not here to support or oppose the legislation, just to voice our concerns with the life expectancy of the case, the resources, and I think the public defenders, more than any other group, would be affected by that and would need further resources. And I'm glad to entertain any questions. Thank you.
Thank you, Judge. Representative Oakley, go ahead.
Thank you, Mr. Chairman. So I have a lot of questions or a lot of discussion that's come to my mind throughout this. I guess I'll start with the Larson case. I was a little surprised to hear your characterization that it didn't have the effect that I believe it does, and I believe that the AG has stated that it did. Specifically, you just said that they said it just has to be a matter of great import. While that was mentioned, it also said that it cannot appeal matters of first impression, and then specifically said, since this motion was grounded in the Fourth Amendment, that didn't raise any constitutional question of first impression. Therefore, that means all Fourth Amendment search and seizure, the heart of criminal cases, is not included. So I guess I'll ask your response on that, although I don't think that that was a fair characterization of that holding, which I think is important because that's obviously one of the reasons that we're here. So just starting with that case, and we'll, I guess, probably just let you respond and then we'll go from there.
Sure.
Yeah, here we go. Okay, so which one of you judges wants that one? Judge Sanford, or you want to go with Judge Wilkie? Judge
Chairman.
Wilkie, go ahead. Either one.
Mr. Chairman, respectfully, I think it's better that he answer it. I didn't make the comment about the Larson
Okay,
case.
there's been a fumble of the football, and it's picked up by Judge Sanford.
Mr. Chairman, I
Gotta
think
run
that's
with it.
fair. I'm not sure I would say that all matters of Fourth Amendment are off limits for appeal. I didn't take that away from the Larson case. And I think if we look at the Fourth Amendment and we look at the Wyoming corollary to it in the Wyoming Constitution, it involves reasonability. As the Supreme Court said, that's the touchstone of the Fourth Amendment. That is necessarily a fact-intensive, a fact-driven inquiry. Again, when I read that, I don't take away that all Fourth Amendment issues are final and not appealable. I just don't. But absolutely, the Larson case does limit appeal, and it is essentially discretionary. And the Supreme Court has interpreted Rule 13 as it did. And I will add, that was a case that involved not a car, but a home. It involved the search of a home in circuit court. So again, why is the circuit court judge speaking on the topic? That was a circuit court case.
Thank you, Judge. Follow up, and then I'll get to others who would have questions as well, but Representative Oakley, you said you had a couple, so.
I'm
go
just
ahead.
getting started.
I was thinking so. So going away from just the Larson case, because we're clearly dealing with a bigger, issue here. And so not just the Larson case, but we know, and it's been presented by the AGs, we have information in front of us that generally this hasn't been something available to the state. And that's really what we're discussing here, regardless of that. It hasn't been used, that it felt like Larson closed the door on what was already a small window and not really something that was available. So I guess I felt like I heard a couple times that, the judiciary wasn't gonna weigh into policy, but to be honest, it was fairly strong from my perspective. So the question is, I feel like I expected a little bit of Chicken Little on this from my perspective, maybe from laymen. But I guess what I'd like is from practitioners on the ground is to get a real estimate of what we would be talking about here. And I can say from my perspective as a practitioner directly in this for well over a decade, I don't see this sky coming down and that everything being appealed. And it bothers me a little, to be honest, to kind of couch it in those terms. As we heard some questions from people who aren't practitioners worried about how much this is going to cost, or public defenders, having this big caseload. But if they understand the suppression motion, for example, that they'd be talking about, they've already written, right? The defense attorney, for example. So the judge has to make a decision on the appellate decision on that. But there's not a ton of more work. There would be work on the state in order to do the appeal, right? But if the state is willing to take on that work with no more resources, no more time than they have, so I don't think that's gonna happen a ton, don't you think that the reality is this creates an avenue to appeal that is fair for justice? Judge Wilkie.
Thank you, Mr. Chairman and Representative Oakley. The policy decision is yours to make, and that's the beauty of separation of powers, which we hold dear and we respect completely. I'm not saying anything about, oh, we're not gonna do the work, or it's gonna be, an avalanche. I think that is a little bit unknown right now about how much it would be used and in what ways it would be used. I was told when I was first on the bench by a very, very wise judge, the legislature puts the laws in the green books, we deal with the things that come out of the green books. And, that's what we're talking about right now. We're just trying to, inform about what impacts it could have on us as far as workloads and shifting of some priorities. Everybody wants to get it right. And I agree with the Attorney General's representative statements that that's what the whole justice system is about. Judges do get things wrong. I'm the first to admit I've made many, many mistakes, and the Supreme Court is always very kind to point those out to me when they reverse me. I've tried to be kind if I ever reversed a circuit court judge.
You've been reversed before?
Yes, can you believe it?
Let me write that down.
Humbly so, Mr. Chairman. I can just tell you as far as I have some figures for appeals in fiscal year 2023. And, in Natrona County, we only had 18 from lower courts. And so I'm not saying it's going to be a deluge, but I also am unclear about how prosecutors and county attorneys are going to view this. And I think you and Representative Craigo know this just from your colleagues. You all have different ways of running your offices. You have different philosophies about what's important and, you know, what is critical in a case. And so that's why I said I think it could impact jurisdictions disparately, given how the county attorneys plan to go forward in this arena. I know you have said that, well, the defense already wrote the suppression, the state's got to actually do a brief. Well, and then the courts have to review both of those, and we have to review the whole record. You guys have lived that record when you did the proceeding. We have to look at that as a cold record and make a decision and enter an order. And that is, it takes time. It doesn't even, it takes the time of the judge and the staff attorney. But, you know, as has been mentioned, it also is going to take time out of your prosecution. And it's not, you know, under the regular appellate rules, you've got to give time for each side to do those submissions and then for a judge to rule timely. And so it's time and personal capital, but also time in the life of the case. So I hope that answers your question, Representative.
So Representative Oakley, I'm going to just check real quick. Do we have some other questions? We do over here. I think that Representative Craywell has one. I'm going to come back to you for a follow-up or two, but then I do want to get to some other questions as well.
Sure, if I could just, the ending of that, I asked a multi-part question, so I just wanted to just kind of finish with this. I asked, but as far as fairness, do you think that this would be fair as a policy directive, we choose to do this, do you think that this is in the matter of fairness?
Mr. Chairman, Representative Oakley, that would run afoul of my ethical obligation to not take a position on policy matters that are solely within your purview.
Okay.
Respectfully.
Fair enough. I'll come back to Representative Chestik. Representative Craigo, you had your hand up, I think, a little bit before that. So.
Thank you, Mr. Chairman. This might actually be a question for Lisa. I'm just curious, what are the statistics statewide, not just Natrona County, not just the 7th, but what are the statistics statewide on appeals from circuit court to district court, and then district to the Supreme Court, and then also on those that are discretionary, how many of them were granted versus not?
Ms. Butler, that one might be in your wheelhouse, is what I'm thinking.
Mr. Chairman, Representative Craigo, I may be able to answer most of those questions, but possibly not all. So I can give you the most recent annual statistics from both the Supreme Court and the district courts, broken down kind of by case type. So overall, the Supreme Court had in 2023 had 153 criminal appeals, 96 civil appeals, 9 administrative agency appeals, and keep in mind that those were appealed to the district court and then appealed to the Supreme Court. 38 writs, and then a few other kinds of cases that included things like attorney discipline. At the district court level, statewide, there were 52 administrative agency appeals, 27 appeals from limited jurisdiction courts, and those were in civil cases, 42 appeals from limited jurisdiction courts, and those were in criminal cases, and then 2 other kinds of appeals. So those are our stats for the last year. So 2023 in the Supreme Court, and then it was fiscal year 24 for the district courts. As far as the discretionary appeals, that is something I'd have to dig into a little bit. I don't have that right in front of me today.
Okay. Representative Chestik.
Thank you, Mr. Chairman. So I have kind of a comment that I'd like to have some reaction to from the panel, but also a specific question after my comment. So what I'm taking away from this discussion, disclaimer, I did not practice criminal law. I was a civil attorney, so I'm kind of out of my element here a little bit, but what I understand from the conversation is that prior to the Larson case, there was a limited window, as I think Representative Oakley describes it, a limited window for discretionary appeals to the Supreme Court. And that the Larson case came along and almost slammed it shut, or at least narrowed the window, or maybe even slammed it shut. So if that's a fair characterization, it seems to me that the policy decision that this committee has to make is, and the bill that's draft before us opens that way wider than it was before Larson, as I understand the bill. So the policy decision that we as a committee have to make is, do we want to open it all the way? We don't want to open it back to where it was before. Are we okay with being narrowed? That's our policy decision. But my question first I'd like to have your reaction to it, whether I've got that right or not. I'm not sure I do, but I think that's close. But the more specific question is, if we decided as a policy matter to go back to the narrow window that existed before Larson, can we do that? And the question there then is, how was the Larson case decided? Was it decided on constitutional grounds? Was it decided as an interpretation of a rule that we could change? So, I mean, if it's a constitutional question, we might have some problems with trying to overturn the Supreme Court with a bill. But if it's a matter that this committee could address by statute, I need to know that right now. So I'll throw it open to the panel.
So, Ms. Butler?
Mr. Chairman, Representative Chestek, I can tell you I'm a little uncomfortable interpreting Supreme Court case law. And so, what I would say is the case is published. You're welcome to read it and determine how you interpret it. The policy issue really is that. I think the question for you all to decide is, should there be a state's right to appeal? And what does that look like? That really is the policy issue that you all have in front of you. It is, at this point, based on a bill of exceptions. It's statutory and under rule, and it is limited. And I think if you want further legal analysis of that opinion, you have some very fine attorneys sitting over there to my left who might be able to write you a memo on that.
Okay, I'm looking back at Representative Oakley. Back to you if you had another one. I'm looking at Representative Crago and others. Any other questions of our panel? Representative Preventa.
Thank you, Mr. Chairman. Correct me if I'm wrong on this, but my understanding is under federal appeals process, you can appeal like Fourth Amendment concerns or issues of law. It doesn't go as broad as this. And I'm wondering if we match the federal appeal process, if you're familiar with it, if that would be more limited than what we have today. And maybe you can't answer that, I guess, with your, I don't know the federal appeal process that well, so I don't know what they do. I'm looking for other models that aren't as broad, because I think what we have been given is extremely broad. Maybe a question I can ask you that you can't answer, I'm sorry, is the competency issue. Because one of the things that exists in the bill is that is that the competency could be appealed. And maybe, I think, for education of this body, there's competency and then there's not guilty by reason of insanity, two totally different things. And it sounds like the case that was brought up by the AG's office was the competency then could have resulted in this person walking, but that's not how I understand competency hearings. My understanding is we wait until you're competent to stand trial. So I don't understand how the AG's office says that person could have walked. They did. I guess, can you please make sense of that for me and maybe members of this committee that aren't familiar with a competency hearing process and what that looks like and what it would mean specifically if we can appeal those? Thank you.
Mr. Chairman, Representative Preventa, it is a very well laid out process in the statutes, and you have to be fit to proceed. And sometimes people meet both of those criteria. You're not fit to proceed. And we have to get you to a point where you're fit to proceed. And sometimes that involves being at the state hospital and perhaps being medicated, sometimes forcefully, to get you to be fit. And then an attorney can say, okay, my client is fit, and now we can effectively communicate. And now I also believe that they were not guilty by reason of mental illness at the time that the crime was committed. And so that's a completely separate evaluation that occurs. And throughout all of those, there's always the opportunity for the other side to say, I don't agree with the report that that professional put forward. I have some other expert I would like to use. And then there are evidentiary hearings before a judge. Those happen at the circuit court level and at the district court level. Sometimes they happen in both because people's competency can wane. And so each time that would maybe be the subject of an appeal, I think you can imagine the timeline would be far extended. And it's already an untenable timeline right now. I think everyone understands and appreciates that. But, you know, I have had several cases before where we have had to wait for a long time to restore someone to be competent to stand trial. We've been successful in doing that. They've stood trial and the jury's rendered a verdict. So I'm unfamiliar with the case that you were referencing previously.
Judge Wilking, thank you. I'm gonna ask the committee to stand down for a moment. We've got a county attorney and a representative of all county attorneys wanting to testify on this on screen, and really appreciate the panel. Thank you, both judges, and Ms. Butler, thank you, and we may fire some questions at you a little later. Let's go to our Sublette County attorney, who's been standing by patiently. Really appreciate it. Take it away.
Thank you so much, Mr. Chairman and members of the committee. This has been a great conversation so far, and I appreciate everybody's comments. I'm here to speak in support of this bill, and I just wanted to speak briefly about my experiences with appeals and how often these will occur. I want to start there and then back into my experiences. First and foremost, prosecutors, by rule, are ministers of justice. That is our role. We look at a case to determine, we look at facts from a police report, first and foremost, to decide, will we file charges? What is the just outcome here? That minister of justice role continues on through the entire life of the case. And rest assured, to echo Mr. Itzen, we have plenty on our plate. We're not out there looking for opportunities to create more work for ourselves, especially the county attorneys, because we wear two hats. We also represent our counties as a governmental entity, which is its own ball of wax. My phone has rung multiple times while I've been here, and it's been my other clients wanting to talk about legal issues. But I want to talk about my experiences with appeals. About 4 years ago, we had a criminal case that started out wherein a sheriff's deputy pulled over a gentleman hauling livestock in Sublette County for a livestock inspection, which is allowed without reasonable suspicion or probable cause of criminal activity. That gentleman sought to suppress all evidence following that traffic stop under the Fourth Amendment. And a magistrate at the circuit court level, and then later after that, the circuit court judge ultimately determined that the constitutionality of the Title 11 statute that allowed for stops for agricultural searches was unconstitutional. Something that we were completely blindsided by. I believe it was Judge Wilking that mentioned this before, that mistakes happen. Judges are lawyers as well. They're still humans. Everyone makes mistakes. But ultimately, in that seeking of justice, we have to look at what are the potential consequences of letting something like that, a ruling that essentially declared a statute unconstitutional from the circuit court. What kind of effect that has on the lives of people in our communities, since that's who we ultimately represent as the state of Wyoming. In that case, we asked for a writ of review. It was an extraordinary situation. We asked for that writ and we were granted it, thankfully. That writ, and ultimately the appeal, we were successful. And I want to make sure that you all understand that could have been denied. Simply the writ of review could have been like, nah, we're not going to take this. And there would have been significant consequences. That case also became a federal court case wherein that defendant sued multiple entities in federal court. I was involved in that lawsuit as well, and as well as the AG's office was. And the reality is had that review not been taken up by the district court judge, that could have meant significant liability or could have meant more protracted litigation in that space. I will say, and I'll keep this brief because you all have given the floor to an attorney and we like to talk, even more than the judges like to talk, and you already cut them off. So I'll wrap myself up before you cut my mic. In looking at my notes, I just want to be clear. There will not be a deluge. I know that there will not be a deluge. We all have prosecutorial discretion that you have entrusted us with as the executive in this situation, as we operate in the executive branch. You granted us that prosecutorial discretion, and we will continue to use it wisely. We're not going to be appealing everything all the time. As an example, I will give you an example on this. Defendants always have the right to appeal. We usually only see appeals when things are drastic. One thing that's an example, we do a lot of speeding trials. We do a lot of speeding citations throughout the state. And I have seen my first appeal of a speeding trial came across our desk, and it's something that we're going to be addressing here soon. The first time in hundreds and hundreds of speeding bench trials, I'm seeing an appeal. We're not appealing all the time. Neither are defendants. Litigants don't want to litigate for litigation's sake, unless you're in some areas of this county, which that does happen, but this is not going to be the situation. Prosecutors are not going to be ringing that bell for the sake of it. We're looking out for the safety of our communities and making sure that justice is served. So, and I'll stand for any questions. Again, thank you for the opportunity.
Yeah, thank you, Mr. Milinkovich. We do appreciate your testimony. We're gonna move on through committee. We've got somebody else, and I'm gonna ask Ms. Tucker to come on screen with us if you still want to testify on this bill, and be as brief as you can be. We're moving on through the afternoon. A lot of agenda ahead of us. So,
and
excuse me, Mr. Tucker. Thank you.
Thank you, Chairman. My name is Joshua Stensis. I'm actually the Deputy County Attorney. Mr. Ruby asked me to step in on his behalf and speak. What I would just note for the court is, Judge Wilking noted that she thought it would be different in various jurisdictions. And I guess I would very much agree with that. I think it's very likely that that different jurisdictions handle it slightly differently. But I also agree with Mr. Milinkovich that the idea that there's going to be a large amount of these, I don't think that's very likely. I would just tell you in Johnson County, we've done from the criminal context, we've done 3 writs in 9 years. And that being said, one of those writs was a writ that had to do with a judge who began using private probation that there wasn't statutory authority for. And so when things move in a direction that really there is no authority for, I feel like there has to be some avenue for prosecutors to have some level of fairness when there's conduct that occasionally falls outside the idea of even being within a judge's authority. And so, and very rarely do I feel like judges make mistakes, and I think most prosecutors, I feel like there's been very few writs. So I believe at some level it's important to do these. Some of these, one of the things that can be parsed out in this bill is some of these things are not midstream in a trial. And so when you look at a final judgment at a preliminary hearing or a dismissal under 62602, you likely don't have a defendant sitting in jail. And I think it's important because I do have some of the same concerns that that Judge Wilking expressed. I think it would be just important to maybe parse these out and look at the ones that really don't affect the middle of trial. So that's the only comments I have. Thank you.
Thank you, appreciate it. Anything, committee? Okay, we're gonna move on. Is there anyone else online streaming in who wishes to testify? Is there anybody else in the room that wishes to testify on this issue? It's been worked pretty hard, so I think we've covered lots of bases. Okay, thank you. I'm going to close testimony on this. Committee, I just want to say out ahead of us, we have some work to do. So that can look however we want it to look. We're going to be late in the evening for firearms issues, for example, a report back from that working group. But we do need to get through this afternoon Homeland Security and the Department of Corrections. So I'm inclined to work this bill and send it forward if that is the feeling of the committee. But what is the pleasure of the committee on this bill? Move to pass by Senator Case. Seconded by Senator Cooper. Discussion. Mr. Co-Chairman.
It seems to me that the additional language with regards to the other states from Utah, or in addition to Utah, that the committee might want to consider some of that. Do we want to include any of that other language from those other states, or are we just going to push the Utah-based part of the statute forward?
So I had the same question. I would again defer to the committee, Mr. Chairman, but I think that sending a good framework forward, there's a lot of ground to go as this bill gets worked through the system. If you want to make such a motion, we'll see how that flies. Any other comments? Go ahead, Representative Craigo.
I think I understand what the co-chairman's getting at, and I would make a motion that we replace the language on, sorry, I don't have a paper copy, the language regarding suppression on page 2, lines 9 through 13, replace that language with the language from the Maine statute regarding suppression decisions.
If we go over to the main version, Representative Craig, well, I'll ask if there's a second to that. Was that Representative Oakley? Thank you. You go to page 4 is the main version. Would that be on line 31?
Yeah, Mr. Chairman, that's lines 21 through 23 on page 4.
21 through 23 on page 4 would replace that language, line 9 through 13 on page 2. Does everyone understand what that motion does? Okay. Are you ready for a motion or for a question on that? All in favor of that motion, say aye. Aye. Any opposed, no. That motion has passed. We're back on the bill. Further comments? Let's work this bill page by page real quickly, make sure everyone is on board or understanding of where we're at. Page 1, is there anything on page 1? Anything further on page 2? Page 3? I think that takes us over to section, Representative Provenza. Oh, and I didn't see Representative Chestick. Let's go there, and then we'll come to Representative Provenza. My apologies.
Thank you, Mr. Chairman. Throughout the bill, starting on page 1, 2, and other places, one of the judges made the comment that the word state may be not inclusive of prosecutions at the city, at the municipal level. So maybe if there's a municipal court judge enforcing a municipal ordinance who wants to have an appeal taken, maybe we should replace state with people. Would that cover, I'm just suggesting that that might be a bit more inclusive to whether it's the state or a municipal prosecution, the people would include either one of those. So I'm just throwing it out there as a suggestion. I want to hear some discussion before I make a motion. Because again, I'm sort of out of my element here in criminal law.
Okay,
Mr. Chairman.
Let's let that one sit.
Yeah, Mr. Chairman, I
Mr.
think in
Fuller?
response to Representative Chestick's point, the change would be page 2, line 1, instead of state, probably clear to say city or town attorney, district attorney, or state as applicable.
So I'm kind of spurring the horse to catch up to this one, and I'll think about that. Representative Oakley, can you help? Are you?
I guess I was going to make a comment. I don't know, maybe we should wait for a second,
Yeah.
if one's coming.
We really don't have a motion on the floor yet. This is
Okay.
just a discussion stage on this
I'm
issue.
just going to say I'm against it. Okay, then I'll discuss.
Representative Oakley.
Thank you, Mr. Chairman. As far as that goes, I haven't looked at all this, but bringing up the municipal, to me, especially in light of judges' concern for time and resources, I would actually look more towards keeping it state and possibly even restricting this from municipalities. Those are the lower level offenses. If this is going to create more work for the judiciary, I want it to be limited to something that would be at least circuit court level would be my thought, even though there might be similar crimes. I think I would be opposed to it and would want to leave it state.
I follow what the representative is saying. Does that make sense? Representative Chestick, back to you.
And thank you for that discussion, because as I said, I'm still unclear on some criminal processes. I'm okay with leaving it a state based on the comment of the representative from Riverton.
Okay, we are back on this bill. Representative Provenza, back to you.
Thank you, Mr. Chairman. I think one of the things I'm uncomfortable with in this bill is the issue with the impairment, the competency. I believe that's on page 3, lines 7 through 9, and I would motion to strike that from the bill.
There's a motion. Do I have a second on that one? Do I have a second on that one? Okay, that motion is seconded by Representative Chestick. We now have a motion on the floor, discussion on that motion. Any discussion? Representative Provenza.
Yeah, Mr. Chairman, I think we heard some concern about if we're going to allow for appeals for this, what it could do to people that are incarcerated and needing to get care, and there were questions from the court on what that would look like. I think there's a lot of ambiguity. I think that there's just potential errors that are going to happen for people that are accused that are in mental states that aren't fit to stand trial and so forth. So it seems messy, and I think the bill would be cleaner without it.
Are you ready for question on the amendment? All those in favor of the amendment say aye. Aye. Any opposed, no. No. That motion has failed. We're back on the bill. Anything further, committee? Are you ready for a roll call on the bill? Crystal, would you please take roll on LSO 128.4?
Senator Case? Aye. Senator Cooper?
Aye.
Senator Furphy? Aye. Senator Schuler? Aye. Representative Chestek? No. Representative Crago? Aye. Representative Haroldson? No. Representative Jennings? Representative Nemec? Aye. Representative Oakley? Aye. Representative Provenza?
No.
Representative Rodriguez-Williams? Aye. Co-Chairman Washit?
Aye.
Chairman Landon?
Aye.
Mr. Chairman, we have 10 ayes, 4 noes.
It sounded, Mr. Chairman, a lot like that will ultimately be a House bill, but we'll have to see. We're going to move quickly, and please take a break if you need it as we go along, committee. We're running behind, and so I do want to get to the Wyoming Homeland Security folks and the consideration of LSO 123, disclosure of sensitive information, law enforcement. I am looking over, Katie, is that yours? Would you be willing to walk us through 123 version 0.4 disclosure? Thank you.
Sure, Mr. Chairman. Katie Adams, LSO. So this is 25 LSO 123, Working Draft 0.4, Disclosure of Sensitive Information Law Enforcement. This is a resurrect of 2023 House Bill 145 as requested by the committee at its last meeting. This bill authorizes the Office of Homeland Security to access criminal identification and intelligence information as specified. It does that by amending Section 91627C. Starting on page 2, that would in effect provide that access to criminal identification and intelligence information is available to the Office of Homeland Security for the purposes provided by Section 1913-105. That section addresses the Homeland Security Program, including the duties of the director. And then moving on down to the staff comment, there are just some suggestions for the committee to consider in terms of possibly improving the existing language and clarifying some of the references that are there. And the effective date would be July 1st, 2025. And with that, I would stand for any questions.
Committee, any questions of Katie? Nice work on this. Thank you for your work to get it to us. This is a return, and we've spent quite a little bit of time on this bill, but I'm anxious to get to the director who's been patient with us all day. Thank you, Director Budd. Please come forward. It's great to see you, and we look forward to your thoughts on this consideration of 123.
Thank you, Mr. Chairman. Appreciate you taking the time to take a look at this. I will let my colleague introduce himself.
Good afternoon. I'm Ronnie Jones with the Division of Criminal Investigations. Thanks for having me.
Mr. Chairman, I just wanted to review some of the duties of the Office of Homeland Security, as well as looking at how we can continue to develop and strengthen our partnerships with law enforcement and make the work at the state level both more efficient and effective. Actually, within our statute, with the Homeland Security Act, coordination with law enforcement is actually mentioned 6 times. It's very important that we have the ability to have not open conversations, but appropriate conversations with our law enforcement partners. The Fusion Center also is within the Division of Criminal Investigation, and we work very closely with them. Our critical infrastructure program analysts provide services and intelligence to that Fusion Center as well. In addition, I serve as the Governor's Homeland Security Advisor, appointed Homeland Security Advisor. My job is to make sure that the Governor has all of the information he needs to make decisions. And I also act as the main point of contact for the Federal Department of Homeland Security in the event of a disaster, emergency, or acts on behalf of the Governor, and I act on behalf of the Governor in these situations. So it's very important that I have all of the information for any situation that is going on that is appropriate. I would make a comparison to having a security clearance in what we're asking for today. If a person has a secret security clearance, that does not mean that they get to see all information that is classified at that level. There has to be a need to know. And this is exactly what we're talking about here. The people who own that information have to believe that there is a reason to share that information with the person who has the security clearance. This would be very similar in that law enforcement owns the information. It would just allow our office to be able to receive information as they see fit and see that it's important for us to have that information, again, on a need-to-know basis. We've worked hard in partnership in trying to develop those partnerships and believe we're doing a good job in making that happen, and that this is imperative, especially in the world that we're living in today, which includes nation-state threats to our state, where we are able to share information that is needed in a timely manner. And I'll stand for questions.
Thank you, Director. Appreciate that. Senator Schuler.
Thank you, Mr. Chairman. Just a question when I was looking through the information and kind of pondering this bill. Had there been problems in the past with being able to access the information that you needed to be able to do your job? Or is this just something where law enforcement was worried about folks getting a hold of information that they didn't think anyone else should have? Just out of curiosity, what's your thoughts on that?
Mr. Chairman, Senator Schuler, I think it has come to light, and I might let Director Jones answer that as well, but it's come to light that there's some concerns for making sure that we protect ourselves with the sharing of that information, and I'll let Director Jones address that.
Director Jones, good afternoon. It's good to see you.
Good afternoon, Mr. Chairman. Thank you. Within 91627, it talks about liability. I'm sorry, I should have been a little bit, I wasn't expecting that, but the way we look at this current statute is, this statute gives us the authority to share criminal intelligence information with law enforcement agencies, State Board of Parole, and the Department of Corrections. Over the years, our partnership with Homeland Security has expanded and grown. Specifically, with the Senate File 77 that passed last year, part of that bill provides us with the responsibility to investigate acts of terrorism within the state of Wyoming. Well, Homeland Security obviously is intertwined with any act of terrorism within the state of Wyoming, and so there's never been a situation where we were uncomfortable with sharing information with Homeland Security, but we were concerned that we were violating the law if we shared that information. And so what we've done up to this point is it takes our analysts time to scrub information that we think they need to have so we're in compliance with the law. But that's inefficient, and sometimes we're not able to get them the information that they need because we feel like we do need to comply with the law. And I'll give you a good example of this. I don't know how the critical infrastructure bill how that's going to play out as it relates to sharing of information, but if we have a meth lab or a bombing in the state of Wyoming, and we have to call the regional response team, well, Director Budd is in charge of that regional response team. And the way this law currently is written, I believe that it would be a violation of this law for me to call Director Budd and request those resources and say, we had a bombing at this address. It's likely criminal in nature, but we need your resources. I feel like that's a violation of this law. So it would certainly make things more efficient, and I think it would allow Director Budd and her staff to fulfill her statutory duties in a more efficient manner.
Further questions? Just one quick clarification, make sure we're real clear here. This has no implication for the federal Homeland Security folks, right? This is just the Governor's Office of Homeland Security that we're addressing in this bill, correct?
Mr. Chairman, yes, you are correct.
Anything further? Anything further from the two of you? Very good, thank you so much. Any other witnesses in the room wishing to testify about this bill? Chiefs or sheriffs, nothing? No, sir? Very good, thank you. All right. Committee, what's your pleasure? So as a motion to move the bill by Provenza, second by Nemec. Discussion on the bill. Sensing an urge to vote? Roll call, please.
Mr. Chairman, this is a roll call vote for 25 LSO 123, disclosure of sensitive information, law enforcement. Senator Case? Senator Cooper?
Aye.
Senator Furphy? Aye. Senator Schuler? Aye. Representative Chestick?
Excused?
Representative Crago? Representative Haroldson? Representative Jennings? Representative Nemec? Representative Oakley? Representative Provenza? Representative Rodriguez-Williams? Co-Chairman Washit?
Aye.
And Chairman Landon.
Excused?
Mr. Chairman, we have 12 ayes, 2 excused.
Thank you very much. Our next order of business, figure out where I'm at on my list here. Wyoming Department of Corrections. Director Shannon. This is explain to the co-chairman how fast we can move along when he's not in the room. Right? All right. Brian, you want to walk us through 25 LSO 124? Or Katie Adams, very good.
Sure,
Ms. Adams?
Co-Chairman Washit. So this is 25 LSO 124, Working Draft 0.5, Restoration of Rights Amendments. So this bill draft incorporates changes to the Restoration of Rights Statute, Section 713-105, as requested by the Department of Corrections and the committee in June. As background and for a little bit of context, Section 610-106 provides that a person convicted of a felony is incompetent to be an elector, juror, to hold any office of honor, trust, or profit within the state, or to use or knowingly possess any firearms unless one of 4 things has occurred. His conviction is reversed or annulled. He receives a pardon. His rights are restored pursuant to 713-105A or F, or his rights as an elector are restored pursuant to 713-105B and C. Section 713-105 addresses restoration of rights by the governor and by the Department of Corrections. So subsection A addresses the governor's rights. Subsections B and C address restoration of rights by the Department of Voting Rights. Subsection F addresses restoration of other rights, including firearms rights by the department. And so what this bill does is it amends section 713-105 to do 4 things. It clarifies who's eligible for restoration of voting rights by the department. It expands the scope of judicial review of restoration of rights eligibility determinations by the department. It amends the notification requirements regarding the issuance of restoration of rights certificates. And it clarifies the effect of a new felony conviction upon a prior restoration of rights. So on pages 2, 4, and 5 of the bill, subsections A, B, and F are amended to reference a new subsection H. And if you jump over to page 6, that new subsection H provides that upon conviction of a new felony under the laws of the state or the United States on or after the date a certificate of restoration of rights is issued under this section, the certificate is automatically void and all rights that were deemed restored by the certificate shall no longer be deemed restored. Turning back to page 3, subsection B2 is amended to clarify that a person is eligible for a certificate of restoration of voting rights by the department only if prior to conviction the person had the right to vote or would have had the right to vote upon attaining the age of 18 years. Still on page 3, subsection D is amended to specify that any determination by the department that a person is ineligible for a certificate of restoration of rights, not just voting rights, is a final action subject to judicial review. So all of those determinations would be subject to judicial review. That subsection is further amended to require the clerk of district court and the Division of Criminal Investigation to cooperate in providing information necessary to determine a person's eligibility for all of those types of restoration of rights, not just voting rights. On page 5, subsection G specifies who the department must notify when a certificate of restoration of rights is issued under subsections A or F. Paragraph I is amended to require the department to notify the Federal Bureau of Alcohol, Tobacco, Firearms, and Explosives if the person was convicted under federal law. And then a new paragraph 3 is created to require the department to notify the Division of Criminal Investigation. There's a staff comment on page 5 noting that the committee may wish to consider whether to require a certificate issued under subsection F to be submitted to the clerk of district court in which the person was convicted in Wyoming, similar to the requirement that's currently in subsection D for a certificate of restoration of voting rights. And then there's a staff comment on page 6 that notes some additional amendments that the committee may wish to consider to account for the department's authority to restore rights under subsection F. So those amendments would be to section 111-102, which addresses the right of a convicted felon to serve as a juror and currently only references the governor's right of restoration there. And then also section 25-104K, which currently only requires the department to issue certificates of restoration of voting rights. And finally, the effective date would be July 1st, 2025. And with that, I would stand for any questions.
Thank you, Katie. Well done. Committee, any questions of the drafters of the bill? Any questions? Okay. Director, thank you for your patience today. Appreciate you being here and being around. Would love to hear from you regarding this bill and refresh a little bit and point out anything you'd like to emphasize or whatever. So,
Mr. Chairman, co-chairman, committee members, my name is Dan Shannon. I'm with the Department of Corrections. I will do a brief overview of how we got here today, Mr. Chairman. When 713-105 passed in law on July 1st of 2023, it also provided an opportunity for individuals with a nonviolent conviction for first time, as well as completed their period of incarceration and probation and parole. 5-year period has elapsed to also offer, as you're aware, right to be a juror, firearms, etc. With that, I can report out to you, we've received since July 1st, 1,125 applications from our citizens, of which 884 were approved and received a certificate. We also filed appeals, and we received 35 appeals, which the department had approved. We have 58 individuals presently, since July 1st, received certificates that are from U.S. District Court, which means they had a federal conviction, but they're Wyoming residents. With that being said, voter rights have been restored to date as 44,315, and 919 citizens have had their rights restored. So with that being said, I would just like to make a few comments, Mr. Chairman, with your approval concerning the draft for 124.
So committee, any questions of Director Shannon? Yeah.
May I continue?
Yep.
All right, thank you, sir.
So I think I just answered my own question, Director. I think I'm good. Anything else, committee? Are we good with the director? Okay, let's move on to Oh, Representative Craigo, go ahead.
Thank you, Mr. Chairman, and I obviously was not at the June meeting, so I wasn't part of that discussion, but I guess my question for the director is, back during session or right before session, we had questions regarding how this applies to convictions under federal law and whether this does apply to convictions under federal law and the issues we were dealing with the ATF, et cetera. And do these amendments address that, or do we need to make other changes within the bill draft to do that, or do nothing at all? And I guess I'd just like your advice or thoughts on that.
Director Shannon, go ahead.
Mr. Chairman, Representative Craigo, if I may, I testified that we've had 48 individuals since last year receive certificates of rights that were convicted within a federal court. I made multiple attempts, but I were able to meet with the ATF here in Cheyenne. And on July 23rd this past year, a notice was sent out to every one of those individuals indicating they were in violation of, actually, they were in violation of, I believe, if you bear with me, it's Federal Statute 922G1, and indicates that a convicted felon also only can have their rights restored that was convicted in a federal system under the federal. So with that being said, I do feel an obligation that I received quite a few contacts from these individuals who we restored their rights and requesting. Now, we're not there to provide any legal guidance, but these individuals, I believe, potentially could be exposed to whatever the federal agencies determine in the future.
So go ahead, Representative. Yeah.
Thank you, Mr. Chairman. So I guess a bit of follow-up. Do we need to clarify that in the existing statute? Do we need to work on that? I mean, originally, I know when we talked about this a couple years ago, we, as the legislature, were addressing what we thought were state convictions. Do we need to clean that up in here and limit your authority to grant those restoration of rights to only state convictions so that we don't get people in trouble or not? I mean, what kind of guidance can you give us? What would be helpful to you? Because I feel like we might be leading a few of these folks down a path that they weren't expecting.
Hope that makes sense, Director Shannon. Can you weigh in on that for us?
Yes, Mr. Chairman, Representative Craigo, I believe that we are exposing those individuals with federal convictions that I'm issuing certificates to. And I'm certainly not here to suggest policy, but I also believe in my heart that I have a responsibility to report to this committee that these individuals are exposed, because that's it. That's completely up to the federal agency what they want to do. And what I feel, well, it doesn't matter how I feel. I believe it more appropriate that the Department of Corrections issue certificates only for state or Wyoming state convictions.
I think I didn't hear the last part of that very well, Director, but it sounds like you're comfortable with the drafting of this bill as it stands right now.
Mr. Chairman, at the conclusion, I would ask just to make a few more comments as the draft bill is saying.
Okay, yeah, thank you for clarifying that. Please continue.
The only comments that I have on reference to page 3 on lines 5 through 8, and before conviction, a person has the right to vote. We currently have in we're just changing, we being Department of Corrections is only changing a procedural, because we currently have in statute the right to vote, to be a juror, and elected official is a requirement to be a U.S. citizen. With that being said, the only other comment that I would have is, it was from our staff comment, to consider whether the certificates would be issued to the clerk of district court, and we do that at this time. So at this time, we do provide a certificate to the district court as well. That was under staff comments. But however the committee wants to direct, we'll continue to do so.
So we do that already, and the change then, Director, would be that this would just dictate in statute that would require you to do so.
Correct.
Gotcha, okay. All righty. Representative Haroldson.
Thank you, Mr. Chairman. Director Shannon, thank you so much for coming and bringing this today. Obviously, this is a conversation we've had. This is a conversation this committee's had, and obviously coming out of 2023, we kind of walked into a new world that we had never really been a part of. So I definitely, kind of jumping on with Representative Crago, we don't want to be in this position as a state where we put people into a tight spot. I do appreciate page 5 where we actually are now notifying ATF, which is important. And that's an alignment that I think is good, but I think at the same time, we shouldn't be issuing to those that we don't have jurisdiction to issue to. Because at that point, it's kind of the golden ticket that's fake in a way, if we're not careful. So is there a place in this that we could insert that? And maybe that's, I don't know if that's to your department or if that's to our LSO staff. And then the second question, so that's number one. Number two is, there is a conversation in that original draft where we inserted some language that actually brought some gun control into the statutes that maybe didn't need to be in there. And can we address or talk to if that's something that we've looked at or something that we could look at?
Director Shannon, go ahead.
Mr. Chairman, Representative Harrelson, thank you for those questions. In reference to where our policy oversight would go into the language, I would refer that to our LSO staff. Concerning your question, and I would ask that you repeat it, I'm not familiar where our firearms concerns that we're being affected with.
Mr. Chairman?
Go ahead.
Thank you, Mr. Chairman. Director, just in the fact where we put into statute that they lost their rights under Wyoming statute, so then we could reinstate their rights. That in itself, we for the first time ever put in Wyoming statute that felony conviction was a loss of firearm rights, which I struggle with believing needed to be in there. I think that was a miscue on the original draft, and I just am wanting to talk about the logistics of that stance and kind of maybe where your department is, if that's a feeling that you have. Maybe I'm asking those impossible questions, but I just wanted a little clarification.
Mr. Chairman, Representative Harrelson, if I may, I think I can answer your question the following. It is clear that they lost their rights, and then that's why we're reinstating. I think it established the guidelines. But I would like to respond to you in the sense that all these decisions are open to judicial review. And during the past 17 months, we've not had one concern. Thank you.
Representative Chestik.
Thank you, Mr. Chairman, Director Shannon. I'm still a little confused as to why we're doing this or what the point of this whole thing is. So looks like the major change in this bill is the addition of subsection H, which clarifies that a new felony conviction will revoke the prior certificate. What is the problem we're trying to solve? So without this bill, somebody's convicted of a felony, they lose their rights to vote. They can be restored under the other sections A through G, that you can restore them. Wouldn't a new conviction result in a new denial of rights? And why do we need H? Wouldn't the new conviction just automatically have the effect of denying somebody the right to vote?
Mr. Chairman, Representative Chestik, thank you for the question. In July 1st of 2018, under 713-105, the individuals that met that certain criteria were given the right to vote. And then in 23, we expanded that. During Senate File 120, we indicated it's automatically no process. If you have a second conviction, that you would lose your certificate. That was never addressed into voting rights. So that simplifies it. And really what it does, it brings 713-105 that address voting rights as well as restoration of additional rights under one statute. So we did say if you have a second conviction, you're going to lose your right to be a juror and as such. That was never addressed under voting rights. So it was more of a simplification of the act. Thank you.
Okay, anything further for Director Shannon? Anything further? Okay, Director, thank you. Stand by on this one in case there's other questions. I'd like to go to anyone else who would like to speak on 124, the Restoration of Rights Amendments Bill. Anybody in the room that wants to testify on this bill? Is there anyone streaming online? Okay, we will close testimony. Move due pass by Senator Case. Do I have a second? Second. Seconded by Senator Cooper. Discussion on 124.5. Senator Case.
How would we structure an amendment to limit it just to state law, state courts? Because it's in all these different sections, and so I'm not sure how that would go.
So, Katie, you were the original, you were the drafter of the bill. Did you hear the question by Senator Case?
Chairman Landon, I missed it.
How would we structure limiting this restoration simply to those convicted in the state and not at the federal level?
Chairman Landon, so Brian and I talked about this a little bit, and I think it's subsections B and F, we would need to specify that it only applies to convictions in the state of Wyoming. And I don't have the exact language for that, but it would, I think we could do it in those two subsections.
So it could be a conceptual amendment that maybe you could draft on our behalf?
Can we hear from Craigo first?
Representative Craigo.
Thank you, Mr. Chairman, and I guess Brian and Katie can pull it up, but I think it's actually in subsection C, which is not in the bill draft, but is in the current statute.
So you'd have to do it there too?
Where that, because it addresses the two types of restorations we can give, and one is, so I'll just paraphrase, but it's C little I is for persons convicted within Wyoming of a nonviolent felony or nonviolent felonies arising out of the same occurrence. And then little double I is for persons convicted outside of Wyoming or under federal law of a nonviolent felony or nonviolent felonies arising out of the same occurrence. So I think you could just take it out of double I where it says federal law. So we could still apply it to other outside of Wyoming and under state law. I think we'd have to clarify that it's under state law outside of Wyoming and not federal law.
Katie, are you following the discussion and the suggestion by the representative from Buffalo?
Chairman Landon, I am following it. I do have some concern that C is talking about procedures, and I think it may be better to make it crystal clear that the Department of Corrections only has authority to issue these certificates for convictions in the state of Wyoming. So I think there's a piece of that in C that talks about sort of when these are going to be issued, but I think there may be some other places where it may be good to make it very clear.
And Mr. Chairman,
Go ahead.
I'll take a stab at an amendment that we give staff leeway on this, but I would prefer that it only apply to convictions in Wyoming state law. I'm not sure what you're going to get into if you, so.
And Representative Harrelson just seconded that motion, so discussion. Let's go to Director Shannon, please.
Mr. Chairman, committee, I just wanted to make a notation in reference to Representative Craigo's under section C, appellate little I, 2 little I. It currently allows, and we have issued 48 certificates for Wyoming residents that have been convicted in other states. So that section, and I had that reviewed through the AG, that it permits, if you're a Wyoming resident and you have a conviction in another state, to receive certificates. So and I don't have any horse in the race either way, but that's currently what the act
So
provides
Director,
for.
would that be considered a federal violation that those that are in-state folks
Mr. Chairman, no,
Concur.
they would be state convictions from other states, but they're Wyoming residents. The example would be if I was convicted of a crime in South Dakota and I live in Newcastle and I meet the criteria, then I applied.
I don't think the motion on the table suggests that we would change that, but Senator Case?
I think it does, Mr. Chairman, but I'm open. I'd kind of like to hear both sides of this.
Yeah.
And I'm looking at the prosecuting defense bench.
Go ahead, Mr. Fuller, while we all ponder.
Yep, so Mr. Chairman, maybe this will help clarify what is going on in this section. So first, just start with page 2, line 9. Subsection A specifies when the governor may issue a certificate which restores the rights lost pursuant to 610-106. I would read that to mean all of those rights specified. Then, Mr. Chairman, subsection B, page 2, line 15, and then subsection C, which is not in this draft, concerns a certificate of restoration of voting rights. So those two subsections only deal with voting rights. Then, Mr. Chairman, we go to page 4, line 5, subsection F, and that concerns all other rights a person has lost pursuant to 610-106, which would be all rights. So I think, Mr. Chairman, the amendment, the committee will need to decide, when we're talking, we want this to only apply to state convictions, of those three pieces. Is it all of them, one of them, some of them? That would be the direction. The language under subsection C that splits out how voting rights are restored between state convictions and then other state or federal convictions, that language only deals with the restoration of voting rights. And Mr. Chairman, I hope that kind of clears up the three pieces here that are being dealt with.
Very helpful. We're going to start going around the bend here. So, Mr. Co-Chairman, then on to the two representatives.
Thank you, Mr. Co-Chairman. Just a suggestion here that perhaps rather than dealing with the due pass amendment at this point, maybe we just get this carried over till our next meeting, but in the meantime, come up with language that would allow us to clarify what we're trying to achieve here.
And Mr. Chairman, and I can certainly work with that when we can back that up. Just on that, since I grabbed the floor, with the issue of voting rights, I think we should be able to restore voting rights no matter what the source of the conviction is. It's the firearms rights that we're trying to keep people from being tripped up in, right? So let's think about it that way.
So I agree with the co-chairman, but go ahead. Representative Provenzio, you had a thought, and on to
Senator
Representative
Case
Krieger.
hijacked my brain. That was my concern. So I think if we remove the motion on the table for due pass, we ask LSO to draft the amendments to ensure that we're only doing state, my opinion would be that we include other states, that we stay away from the federal issue. If you get a felony in another state that qualifies under this, I still think you should get your gun rights back. But we certainly don't want to take away any of the issues with voting rights or any of the other things, so.
Representative, that states pretty much where my heart is as well, so.
So why don't I just withdraw right now?
I was
see if
going
we
to
get a
ask,
second.
Senator, if you'd be willing, and the second is willing. We'll work on that a little bit. It should not take us long to take this bill up on the third meeting of the year, which is November 8th or 10th or coming up. So, Mr. Co-Chairman.
Thank you, Mr. Co-Chairman. I guess I still have a question. Is there a concern on the part of the ATF about Wyoming restoring rights for a conviction in another state? And if there is an issue with them in that regard, then I'd rather see our bill draft in, November be specific to Wyoming convictions, but I don't know where the ATF is coming down on it.
So, Director Shannon, would you be willing to stay in touch with our staff just to make sure you're comfortable with the drafting? And including that question, we'll have to make sure we cover that base. And we'll come back with this bill in November.
Yes, Mr. Chairman.
Okay, All right, thank you, Director. Representative Provenza.
Can we summon the ATF to come here? Summon sounds like more fun, Representative.
Ask, you can ask. Yeah,
Hello, ATF, would you please come to the next meeting?
yeah. Yeah, there's some others we can ask. So, yeah. Okay, thank you, committee. I think that's the right thing. We'll have that bill shined up and ready to go in November. It shouldn't take long. We'll put that on the agenda then. Director Shannon, anything else that you have before we let you get back on the road or whatever you're up to this afternoon?
No, Mr. Chairman, thank you.
Okay, all right. Thank you very much. So
Is there any public comment?
that's where I'm headed next. Any public comment on this restoration of rights? I thought we opened and shut it. So back to Mr. Fuller, I wanted to thank you for the memorandum, which was well done on the justice reinvestment and good time memo that everybody has read carefully. So thank you for that. And on our agenda, I think that was that going to come to you to give a few thoughts on that, or?
Well, Mr. Chairman, I think in the interest of time, that was the request that a member of the committee made. So the memo is just responding to that request. Unless there are questions, I don't have to make any additional comments.
Thank you. That's exactly where I thought. And so please, if you haven't read it, commend it to you. That's well done by Brian. Appreciate it. Let's move on to the next issue on our agenda, the firearms issue. You may recall, committee, that us two co-chairmen suggested that a working group be formed after that first meeting of the year to have some discussions and come back with a report at this meeting suggesting ways we might want to consider going forward with any concealed carry issues, prompted by the bill that passed the legislature but was vetoed. You'll recall that passed both chambers and went on to the governor and did not pass muster there. The Management Council gave that to us as an additional interim topic bill, and so that's why we established a working group. I take much of the blame for that, and I'm saying blame because there was not a robust amount of dialogue on that. Everybody had a very busy summer. We all know why, and but we have some things that we'll share with you today, and then we can carry on from there. So, Mr. Co-Chairman, maybe you could share some of what we came up with.
So, thank you, Mr. Chairman. So even though the working group didn't meet as a group, many of us had some side conversations about this topic, and there are several things that came up. One of those that I suggested was that perhaps we'd have a cleaner piece of legislation if we created a new section of statute about carrying of arms, and have a section dealing with open carry, a section dealing with constitutional concealed carry, and a section dealing with carrying pursuant to a state-issued permit. I just think that gives us a cleaner piece of legislation. Last year, we tried to shoehorn in some amendments dealing with open carry because there were some concerns about, open carry versus concealed carry in some venues. And we were trying to shoehorn that into a statute that was written for concealed carry permits. And so it just seemed convoluted to me the way that bill shaped up. So that was my suggestion. Other suggestions have been perhaps 3 separate bills, one dealing with concealed carry in a broad range of venues without K-12 education being mentioned, another without higher ed, and then a separate bill dealing with concealed carry and higher ed, and a separate bill dealing with concealed carry and K-12. And I thought those were some worthwhile suggestions of possibilities. I did speak with the bringer of last year's bill, and I'll let him speak to his intentions this year. But I think a discussion today might inform whichever pathway legislation might take.
So thank you, Mr. Co-Chairman. Obviously, a couple other options would be to simply resurrect the bill that passed the two chambers, bring it back as is. We could resurrect with some amendments that addressed some of the concerns by a committee on the Senate side and later the governor, which related to firearms in schools and firearms in medical institutions. And then that confusion element that the co-chairman just referenced. So let's take a break for just a moment. I want to recognize our executive group folks who have showed up today to kind of catch us up. As you all are aware, the executive branch has been dealing with the issue, and please come forward. We're anxious to hear from you, Director McComey. It's good to see you and your associates. They look familiar. Ms. Norton, hi, good to see you.
Nice to see you.
You all have been doing some work on this front. Maybe you can catch the Judiciary Committee up on where it stands today.
Okay, thank you, Mr. Chairman. I have with me today Susan Norton. Susan is our administrator on the Construction Management Division and serves then, because of that, as the secretary for the SBC. And Mr. Dave Webb is in the background here. If we need any support, I don't think we will, but just in case. And he is a construction manager supervisor, so manages all the project managers on the construction management side. Yes, there has been some work being done at the direction of the SBC. First, back in April 10th, the SBC brought up this subject and wanted to move forward with some rulemaking. And then, so in the interim between that and August 12th, and I'll talk a little bit about the August 12th date, the governor's office, our AGs, and our office have been working on establishing rules. And so there is a rules committee as part of the SBC, as a working group. So we've been working with that group, and that led to a set of draft rules for discussion. It's not the formal rulemaking process where you'd go out for public comment, those sort of things. It was just to put it out to the public for comment on where we were at with those draft rules to get some feedbacks. And that meeting was held on August 12th. It was a special meeting of the SBC, occurred from 4 to 6 in the afternoon. And so it was open to the public to come into the meeting, as well as we had quite a few folks that were online that attended that meeting also. From that, where we're at today is there was a couple of suggestions made by the SBC following that, and getting back, Senator Landon, to some of the discussion on constitutional carry versus concealed carry, looking at the statutes and that sort of thing to try and make some amendments to the preliminary, I'm not going to use the term draft, but the preliminary rules that the SBC Rules Committee has been working on. So with that, Mr. Chairman, I'll turn it over to Suzanne. She'll go into a little more detail if that's all right with you, and I'd certainly take any questions also.
Thank you. Suzanne Norton, again, Secretary to the State Building Commission. Again, I'd also reiterate that the work that we're doing is intended to be very proactive so that pressure isn't felt as if last year's House bill, if it would have continued through, the rulemaking was to start in 30 days. And it does need to be a very well-informed, deliberate process with lots of public comment and so on. So we are in a very preliminary phase in exploring what changes could or should be made. And the things that are being considered right now are conditional upon repeal or significant amendment of Wyoming Statute 6-8-104, which prohibits firearms coming into a governmental meeting. And then also concurrence by the Management Council of Wyoming Legislature to rules as adopted pursuant to 9-5-106, which requires SBC rules to be, concurred by Management Council relating to the ownership or the working space within the Capitol and the Capitol extension, so that things are not confusing to the public. Our minutes from our special meeting are in draft form right now, and they will come before the State Building Commission on September 9th. The public comment form that's online will remain open until October 2nd. So far, there have been 119 comments received. There are some print forms out on the consoles outside the room. If anyone in the public would like to pick those up, they can be mailed or scanned or provided to us for, to get back to it. The SBC meeting is on October 9th, and this issue will be on the agenda.
Okay. So, Ms. Norton, just real quickly, the scope is pretty broad, is it not? You mentioned this building, this complex, that we call it the Capitol Square, but it goes beyond that. Am I correct in that?
Mr. Chairman, this preliminary draft is only considering public spaces within the Capitol and the Capitol extension.
Oh, okay.
And then it's envisioned that there might be further drafts to consider state office space in Capitol Square and the city of Cheyenne. But as you all know, there's a very broad array of jurisdictions and types of facilities that the state manages, many of which may not be appropriate for firearms to be present.
So part of the concern, or at least the discussion that we had informally to lead up to this meeting so that we could give whatever possibilities to the committee, was just that, which is not to overstep any bounds of work that the executive branch wants to do. And so we're kind of in that time loop. So thanks for helping us to understand where we are, Ms. Norton, on that. Appreciate you both taking the time to come and catch us up. Any questions for either one of these directors? Okay.
Mr. Chairman?
Go ahead, Director.
The work that they're doing on the Capitol right now, and the Capitol extension, to try and clean that up or clear that up is pretty complicated, a lot more than you'd think just by saying we're having the rulemaking here for the Capitol and Capitol extension. And that's due to the fact that there's areas of this building change when the legislature is in session. So what might be proposed on the executive branch at any 1 month could change the next month when the legislature is in session. Yeah. And so part of what we're trying to achieve is clarity for the public also, when they come in the building, at where are they? Because there could be certain times of the year they may be prohibited for carrying in that venue. And again, that comes back to Management Council and the legislature for their role in this building and at what times they see that happen versus the executive branch. So that's part of trying to work with your committee should they move forward with bills and/or when we go through that rulemaking process, certainly have comments from legislators. And at the meeting that we did have, I think there were about 6 legislators that did attend that meeting, either virtually or in person, that gave comments also along with the public.
Well, and I think, Director, thank you for that. That's just one microcosm of some of the things you run into when you start taking this all up. And the co-chairman, I thought, really landed on something that to me seems really appropriate, and that is sometime, somewhere, it would be a good idea for Wyoming to clean up its statutes. I think there's reference to guns in 14 different chapters, if I remember correctly. Ideally, wouldn't it be great to have a chapter just on the carrying of firearms and clear up the open carry, clear up the concealed carry, the constitutional, whatever, And that was the reference that the co-chairman made, but then that requires a great deal of time, which we do not have in this interim. But anyway, really appreciate you both. Thank you.
Thank you, Mr. Chairman.
So I want to get to other folks have come to testify to us, committee, and then we can certainly have a robust discussion, but I want to get to any testimony. And I see the secretary back there. I'm going to ask a favor, though. I want to go to somebody who's right in front of you, Secretary Gray. They have been patient all afternoon, and they've come from far up in the north part of the state to come down here. So, ladies, please come forward. We'll let you visit with us in case you need to hit the road. And many apologies, and thank you for your patience. So
we appreciate the opportunity.
then we'll go to the
Mr. Chairman.
secretary right after that, please.
Okay, I'm Annie Griffin, the superintendent of Washakie County School District Number 2 in 10 Sleep, and I know that I have spoken to some of the people on this committee, and I appreciate the opportunity to speak in front of you. I've also got Ms. Reed, our social studies, 712 social studies teacher, that will also speak a little bit to you. We're here to present some food for thought as this potential legislation proceeds. I want to talk to you about the fact that we are a concealed carry district. We have passed that rule within our district, and we do have staff members that are carrying as part of that rule. That rule is currently working for us. We work very closely with our sheriff's department and have a tight partnership. We are 18 minutes from law enforcement response, and so we feel like this is something that is important to keep our children safe, and that's a decision that was made about 7 years ago before I came as superintendent there. Some things I want you to consider that we have ran into. One of the things is if legislation is passed where someone can come in with a concealed carry permit, and they're just open to carry within our schools in terms of having that permit, how does that work with our employees? And I think as you design this, we've got to think about that, because we like to say that the stereotype of someone with concealed carry, I've heard this before, is that, generally they're law-abiding citizens. Well, so are our educators. However, there have been times where, without getting too far into personnel and into the weeds, that potentially we need to pull a permit because maybe there's been a change in mental status. There's been something that has made us go, it's probably not right for us to continue to have this person conceal carry with students right here in this building. And how's that going to work if we do allow the rest of the people within the school to carry? How does it work when we pull a permit? Is that going to mean a lawsuit for the school district? And so I just think as you're working through this, just to think about some of these things. How could this legislation potentially impact teacher retention, teacher hiring? We were in a position just a couple of years ago where we couldn't get an English teacher. We're a tiny town, and things that I've heard are, how does this impact me as a teacher, as an educator? I'm not sure how I feel about this. And so I think we need to have some conversations with our educators, especially these small districts. We struggle to hire, so how will this impact that? So again, another thing to think about. Ms. Reed will talk to you shortly about what some of the student feedback is regarding this legislation and their thoughts, which I think should be considered as well. My concern is the volatility of this profession. People don't like to hear that, but that is a reality. This is my 26th year in education, and unfortunately, I can tell you of many events of verbal abuse, of violence from students toward administrators, violence from children in the classroom. There's different things that are going on that I don't think people fully understand the volatility that can go on in schools. One of the things I give as an example, I'm a mother of twins, and I give the example of those two girls are my heart on the outside of my body. Schools get parents feel very, very strongly about the safety and well-being, which is part of this, but they also feel very strongly about decisions that are made regarding their children, and we know that. And we want to be partners and stand beside them, but sometimes it takes a little bit to get that across, that we're here beside you, and they come in angry. And so how does this look if we're sitting in a teacher conference and we're concerned that they have a firearm? I can think of a time, I'm special education director, and I can think of a time when I was principal in an IEP meeting, and I had a father that was absolutely violently slamming his hand on that table. That person was a veteran, which I know he'd be able to get a permit like that. And so things like that, we have got to think about because that volatility is real and is there. Some of the other things to think about is just in general, the safety of our children in terms of the number of firearms that would be in schools. How does this look when opposing teams come for games? We can tell our students that they're not allowed to carry, but how does that look when others come? How do we consider all of these pieces as we do this? Another example I can give you that I've had more than one person mention to me is the volatility at ball games. Unfortunately, I had a situation this year where I had to remove or have someone be asked to leave. They refused to leave. I had to stop the game. I had people from the stands yelling at me. And I think about that in terms of, okay, somebody can say, well, maybe there were firearms in that anyway. But other people might say, now there's an increase in firearms if we pass this. Now our administrators forced to feel like they have to carry when maybe they're not a person who feels comfortable carrying, but for the protection of themselves. So again, I just think there are so many things that need to be considered. One of the solutions that I want to offer is that for districts like mine that are without law enforcement in town, yes, we have the Washakie County Sheriff's Department, but if they're not in the area and something happens, right, that's why our concealed carry rule was passed. I ask that you consider putting an SRO in all rural districts like ours. And so when we don't have any law enforcement, please put someone who is trained and consider funding that if this legislation is chosen to be passed. We ask too that educators are brought to the table as part of this, along with our law enforcement. I've been in contact with our law enforcement and had many conversations regarding this. And when it comes to K-12 schools, please let us be heard because we're right there every single day. We love our jobs, we love our kids, we love our communities, and we want the best for them, just as you do for your communities. But please let us be at the table. Ms. Reed?
Superintendent Griffin, thank you. Really appreciate your patience and coming this far. We appreciate your testimony. It kind of brings back memories for me as a former basketball referee, you asking somebody to leave a ball game. Those are great moments, aren't they?
Mm-hmm.
Yeah.
No.
Yeah. Yeah, there you go. So committee, anything for the superintendent? Anything? Go ahead. Senator Schuler.
Thank you, Mr. Chairman. And I think you reached out to me. I can't remember if I got back to you or not, and if I didn't, I apologize. Our district is also, the one I'm in, is also a carry school, and I spent probably 40 minutes the other day talking with their superintendent about how it's working out, you know, what he thinks about it, this, that, and whatever. Very happy with where they are. I think they had about 10 teachers that went through all the courses and the training, and they feel very comfortable, and they feel like that just provides, we have 4 elementary schools, 2 middle schools, and a high school. So it really provides the kind of safety that they wanted. What he did really emphasize is that we don't really want the state to come in and tell us that everybody can, because we're good with where we are. We feel safe. We have an SRO as well as all the teachers that have been armed, and we just feel like that local control matters. It should count for something, and let every district do what they feel more comfortable with. Where your district, chose to do this, I see that there's a couple of other districts that are looking at it, and maybe that's where we should go. I did talk to a couple of other districts who don't have it, and they said, just, we don't want the guns in our schools, period. But I think every district should be able to figure that out and do what they think is best for them. So I appreciate your willingness to come down here and give us a kind of an idea of what it's like in a smaller rural school where you're a little further away from help. And so I appreciate your comments. Thank you.
So Superintendent Griffin, you got someone with you who would like to testify?
Yes, Ms. Reed.
Yeah. And please introduce yourself for the record and welcome.
Thank you, Mr. Chairman. And thank you to this committee for allowing us this time to come and share our thoughts. Like my superintendent mentioned, my name is Emma Reed. I am the 7th through 12th grade social studies teacher in Washakie County School District number 2. I am in the beginning of my 3rd year at that position, and it's been wonderful, and I really, really love it. And I as a social studies teacher and as a government teacher, I felt like it was something I really cared about to be able to come down here and do my civic duty to share a teacher's perspective on this legislation, particularly about the House Bill 105 that came through the legislative body last year. I want to, oh, I'm sorry, was it 125? 125. I want to start by just reiterating that we do have historical precedent of gun regulation in Wyoming from the time it was a territory. I'm sure you all know that, but I thought it might be prudent to just reiterate. There are many statutes and laws and regulations that you can look through, and it goes back and forth, but I want to particularly call attention to the one from 1875, which was enacted for 14 years and did not allow carry in any township, city, town, or village, I believe is the language there. So this is certainly not outside of the historical precedent bounds of Wyoming to recognize that firearms in incapable hands can be potentially lethal and dangerous. And so it is fully within the historical precedent of the state to manage that potential risk. I'd also reiterate Mrs. Griffin's points about the purpose of concealed carry in schools. I really feel that as a citizen and as a teacher, if the goal is to protect our students, that allowing concealed carry of citizens into the schools would place the responsibility of policing society on other citizens, as opposed to SRO officers who can be trained and vetted and who my superintendent and other districts who have policies like this have worked with. SRO officers have systems that can be worked with. Districts can work closely in conjunction with them. And I think that that's really important. And I would say that I am also in agreement with Mrs. Griffin to place SRO officers, at least one, in rural districts like ours where we are a little bit further away from law enforcement support. I'd also reiterate the comments that I heard Senator Schuler make that said that there are really diverse needs in Wyoming and every district has different concerns. And what works for us in Washakie County School District number 2, I wouldn't expect to work necessarily in a district in Jackson or a district here in Cheyenne or a district in Thermopolis or a district in Casper. I think that each of those districts have unique needs and they are in the best position, those school boards are, to be able to determine whether or not they think that it's appropriate for them to enact teacher carry policies like we have. I also now just want to go through, because as a government teacher, I thought that it would be prudent for me to ask my students what they thought of the bill that came through last year and get their feedback, because they can't participate quite yet as fully into politics, but they are affected by some bills that come through. When I shared that bill, pulled up the text of the bill from last year, and we read through the bill, most of the initial reactions from my students were, why? Why is this bill coming up? They didn't feel that this was a problem that needed to be solved. Some, once they thought through what the potential goals of the bill might be, they felt that if it was a concealed carry bill, as opposed to open carry situations where you can quickly identify who might have a firearm and who doesn't, in a concealed carry situation, you don't know, and they mentioned that my students did, that they wouldn't know which adult coming into the building might potentially have a firearm and might not. And there was this concern about the unknown there from my students with that. There was also some talk about trust of other adults, because we don't just have their parents coming in, we also have guest speakers who come in. We have adults from other districts who come in or other schools who come in for sports games, and they don't know all of those adults. And they mentioned that they would potentially become very frightened of new adults, strangers who might come into the building. And when I mentioned that our concealed carry policy in the district is anonymous, the students don't know which teachers are carrying, and other teachers don't know which other teachers are carrying, they said, well, that's different because we trust our teachers. These are teachers we see every day, and we work with them every day, and we trust each and every single one of them. But these would be adults potentially that are coming in that we don't know, and we don't trust them. One group of students asked to review the concealed carry requirements for Wyoming, and after we did that, they felt that the concealed carry requirements for Wyoming are not strict enough to justify this kind of bill to allow any adult with a concealed carry license into a school. I had one senior who does happen to have a younger sister in the school, who will be in the school for much longer than him, obviously, who mentioned that he was very pro-Second Amendment, but he felt that this bill was too far. And some other groups of students asked if, heaven forbid, there were an incident to happen and there were civilians in the building who had concealed carry permits, and law enforcement showed up, how would law enforcement be able to know which adults with weapons were a threat and which were not? And that was another concern that my students brought up, of how are the law enforcement officials going to know if they are coming into a situation late, and how are they going to prevent unneeded violence against people who don't mean the students any harm. And then, like Mrs. Griffin said, with the sometimes the volatility that you have at sports games specifically, some of my seniors brought that up on their own and said they very adamantly mentioned that they did not feel comfortable with the idea of a volatile sports game, audience members like that, knowing that potentially there might be a firearm in the audience. So those are some comments from students whose lives this bill would affect or would have affected. And I just thought it would be prudent as a government teacher to bring those thoughts forward to the committee here today and let you process them. Thank you.
Ms. Reed, thank you. Again, we appreciate you taking the time to do this, and please share with your students. Sometimes it takes a little bit longer to give testimony than you intend, but thank you for sticking around and doing that. Any questions of our two folks from Washakie 2? Thank you so much.
Thank you.
Appreciate it. Okay, Mr. Secretary, I see you at the back. Thank you for helping me to defer to these two fine folks who drove all the way down here from Tinsley.
Absolutely. And if
Welcome,
there's-
Mr. Secretary.
Thank you, Mr. Chairman. Absolutely. And if there is anybody else that really needs to go, happy to wait. But thank you for recognizing me, and good afternoon. I'm Chuck Gray, the Wyoming Secretary of State. I wanted to speak briefly, both in my role as the Secretary of State and as the head of an agency, as well as my experience as a member of the State Building Commission, and the evident need to promote the Second Amendment and eliminate the soft targets, which are gun-free zones in Wyoming. I want to stress that I'm speaking here in my official capacity as Secretary of State and based on my experience as one of the members of the State Building Commission, but that I'm not speaking on behalf of the State Building Commission. There is a problem in that gun-free zones remain soft targets, and I've heard from many of my constituents that the current restrictions on our Second Amendment rights have really opened state facilities, including the Wyoming Capitol, to vulnerability. As Professor John Lott's research has shown, repealing gun-free zones is an important part of decreasing the likelihood of mass shootings. And I think people are tired of hearing that there are no solutions when there are. That we allow people to exercise their God-given Second Amendment rights by eliminating gun-free zones. And there are real challenges from a security perspective. All agencies have them. It's not just the Secretary of State's office. But talking a little bit about what I've experienced as Secretary of State, I received a threatening voicemail in August, also had a white powder sent to our office earlier this week, and the Highway Patrol do an incredible job, the FBI. We've had a lot of Homeland Security, a lot of law enforcement involved in these incidents, but the reality is that these gun-free zones are soft targets. We had a solution in the 2024 session with the passage of House Enrolled Act 49, repeal gun-free zones, which was important and that would have eliminated gun-free zones in a number of different contexts. Unfortunately, this was vetoed by the governor. In his veto letter, he claimed it was an attempt to, quote, micromanage a constitutionally protected right, unquote, which I've always found very perplexing, considering that the bill repealed gun-free zones that abridged our Second Amendment rights. I've asked many times for clarification on this and haven't gotten one, this line in the veto message. Governor Gordon also said that the State Building Commission could make these decisions, and that set off the rulemaking process, which is fine, and I think the staff on the State Building Commission has done what they can. But since then, we really haven't had the type of action that I think we need. There was a hearing and a draft, but nothing that would protect the Second Amendment like the repeal gun-free zones bill would have. I've asked the chairman, the governor, for a schedule on a time frame on this, and really none has been given. I did hear the testimony that I guess it's going to be discussed in the October meeting. But the proposed draft put forward had these jurisdictional issues, and we could have seen this. I mean, we have members who were here in 2019 when the Capitol was reopened. We all remember the debate on the bill, on the fact that there are certain sections of the Capitol that the legislature has jurisdiction over, and there are certain sections of the Capitol that the executive branch has jurisdiction over through the State Building Commission. And it even changes in the middle of the year. Certain sections the legislature takes over during the legislative session. Certain sections they have jurisdiction over the entire year. And since those jurisdictional issues have been raised, now the same person that vetoed the bill is saying that, well, these jurisdictional issues are posing challenges for us to proceeding and taking action. These are things that we could have seen coming. And so where I think we're at is just sort of this circularity, which often happens in government, where we have a legislative solution, an executive veto claiming that the executive branch can act, and then it's kicked back to the legislature because the executive branch solution has challenges. Now, I've always believed that we need to push forward, get this done, put forward the rulemaking, even though it will create this sort of pastiche of areas where carry is allowed in the Capitol complex, and areas where it will go to management council, I guess, or the full legislature to debate in a bill. And ultimately, putting forward the bill again would preempt that rulemaking action. But the reality is that the time for dither and delay is over. We need to have real action. This has been debated for a decade, and the time for excuses that contradict each other is past. I think the decision point is very clear. We have the repeal gun-free zones bill, something that was mature, well-vetted, and that should be tried again. We'll certainly proceed with the rulemaking, but I don't think that's the grand solution that is ultimately gonna fix this issue. Thank you.
Thank you, Mr. Secretary. Any questions of the Secretary? Senator Sheehan.
Thank you, Mr. Chairman. Just to piggyback on the testimony from the folks that drove down, and also my conversations with a number of districts, we talk a lot about local control, and we talk about how important that is. And I don't think we've really brought our educational folks to the table throughout this whole process. I'm just now getting, I think on top of where a lot of them are, and I'm not seeing a big push for them. It'd be nice to get some data and maybe a survey of the districts and see if that's something they really want. If it's something we want, that's different. I had one gentleman come up to me after the session this year and said, well, by not passing this bill forward, we actually, the Senate and the House did, but by the veto, you took away my Second Amendment rights. And I said, you haven't had those rights for over 20 years. Gun-free zones have been around, I mean, maybe it was in the 70s, I can't even remember for sure, but you didn't lose any rights because you haven't had those rights for a number of years. So I'd like to see the data. I'd like to see really what the schools believe, what our superintendents believe, what our kids believe. It was very interesting to hear this teacher talk about her students and what they felt like. And I know we do this all the time in the legislature. We do our micromanage and we say this is what's going to be good for the state, whether it be colleges, whether it be schools, whether it be down here at the Capitol. But I think maybe we've missed the boat on involving the folks that really matter. So what are your thoughts on that in terms of bringing them to the table, the education folks?
Mr. Secretary, go ahead.
Well, Mr. Chairman, I really believe in engagement with the process. I just on Tuesday, as part of Constitution Day, I went to Sweetwater County and We had events with students there talking about the importance of the Constitution. Of course, our office publishes the state constitution on behalf of the state of Wyoming. And I wrapped up that discussion by encouraging them to be involved in our republic. So I certainly think involving all stakeholders, public comment is pivotal. I support the repeal of these gun-free zones, the bill in its entirety. And although my comments have focused a little more on the issue before the State Building Commission, I'll make it clear, I support the bill in its entirety. I believe that that gun-free zones are soft targets. And while I think the media coverage, and maybe it's counterintuitive in terms of the way the media inculcates things, but I think the research will show that these soft targets are very problematic. And I think it's very telling that the district in question did have a policy, but most don't. I mean, I remember when that bill was passed in 2017, and it's had time to be out there and germinate over the past 6 years. And as frankly, we kind of predicted, very few districts are doing it. Now, I realize that there's the local control argument, but I think that this is an important thing, protecting our Second Amendment rights, and that's where I fall on it. So I do want to add one thing, is that one thing about the rulemaking, and I'm curious to see where we're at in the October meeting on this, is that constitutional carry was not part of it in the context of the cap. I want to add that as one of the flaws in the rulemaking. And that was pointed out early on in the public comment period in the meeting. I'm hopeful that that will be revised in the next draft put forward to the State Building Commission.
Okay, thank you, Mr. Secretary.
Thanks.
Appreciate it.
Thank you.
Anyone else want to come up and address the committee with regard to considerations on firearms issues? Anyone else wish to testify this afternoon? Is there anyone online?
Mr. Chairman, we do have Erica Cole online.
Erica Cole? Okay, please let her in.
Hi,
Ms.
can you please?
Cole, good afternoon.
Good afternoon.
Welcome.
Can you hear me?
We can.
Thank
Please
you.
proceed.
Mr. Chairman, my name is Erica Cole, City of Cheyenne resident. I apologize I'm not able to be there in person today, and thank you for accepting public comment on this issue and allowing virtual testimony. I first wanted to state that I agree with Co-Chairman Washett's suggestion to clarify the legislation around open carrying versus concealed carrying in our state statutes. There have been a number of public surveys, both last year related to House Bill 125 and recently soliciting public feedback on dissolving gun-free zones and allowing gun carrying into certain sensitive areas. The surveys that have public results have demonstrated that the public is against these changes. There was a survey last month that the Wyoming Tribune-Eagle posted questioning, do you believe that concealed carry of firearms should be allowed in the Capitol extension between the Capitol and the Hirschler building? 81.1% of responders indicated no, they did not agree with that. KGAB had a poll in March where they questioned, do you agree with Governor Gordon's veto of House Bill 125? 63.3% of responders indicated yes, they were in agreement with the veto. Unfortunately, I don't feel you're going to have a lot of members of the public making comment on this. I know many state employees and educators that feel like their jobs could be at risk if they speak up on this topic. I commend Ms. Reed earlier for making public comment today. It takes a lot of courage. There has also been some level of loss of trust in our democratic process after how House Bill 125 was brought back to life through unprecedented rule amendments during the last session. So why do we have an overwhelming public opinion that do not want gun-free zones removed, but legislators pushing this agenda? Even though there's even many constituents that are pro-Second Amendment and responsible gun owners that do not agree with removing gun-free zones from sensitive areas, including public schools and public buildings. This is not a black and white topic, and it should not be all or nothing. I have spoken with some of the legislators in favor of these changes, and I have heard many of them testify. They have all stated the same concern. They feel like sitting ducks on the floor, and they are concerned about a member of the public coming in with a gun and the Capitol Police not being able to respond in time. Their fears are valid in this day and age, but just allowing anybody to carry a firearm into the Capitol is not going to prevent future tragedy. The building commission needs to limit entrances into the Capitol and install passive weapon screening systems. We have a beautiful Capitol and we do not want to make it look like a prison, but there are many non-obtrusive weapon screening systems on the market with adjustable levels of sensitivity, and they can detect a broad range of weapons. This would address the concerns of everybody I've heard speak about allowing the unknown of somebody carrying a weapon into the Capitol or Capitol extension, because no one would be able to walk through that door anymore with a weapon undetected. This would also increase the public's comfort level with coming to this important facility to express their opinions and have their voice heard. Allowing guns into the Capitol will only limit freedom of speech. The school districts currently have the ability to make the determination about whether school employees can carry guns on school grounds and how to regulate it. That being said, very few have done so. Those that have implemented many safety and security measures far above the minimum statutory requirements. For example, Uintah County School District number 1, where Chairman Schuler is from, or sorry, Representative Schuler, has implemented many additional common sense requirements in their concealed carry program, including but not limited to the employee must be in good standing, not being on an improvement plan in the past 5 years. They must submit to a psychological suitability exam paid for by the school district, and they are subject to random drug and alcohol testing. If the legislator proceeds down a path of trying to dissolve gun-free zones, they should utilize requirements in successful districts around the state that have consulted with their subject matter experts, such as Superintendent Griffin, who have put a lot of consideration into their concealed carry programs. Our state has a history of sensible regulation of firearms in sensitive areas, and there is no reason to change that. Please leave local control to school districts regarding allowing guns into their facilities, and please consider increasing security and weapons screening at the entrances to the Capitol and the Capitol extension to address the fears of our legislators so they do not need to feel like sitting ducks and can focus on more important matters this session. Thank you. I'll stand for questions.
Thank you, Ms. Cole. Appreciate you being here this afternoon. Is there anyone else online who would like to testify? Is there anyone who wants to testify who is here in the room? Please come forward. We know you, but please state your name for the record.
Thank you, Mr. Chairman. Richard Garrett, and I hope it's a good thing to be known. I appreciate being known by this body, that's for sure. I'm going to limit my comments to one specific part of this discussion that I think is important for the committee to have at its disposal and available as you consider how to move forward. I'm going to call your attention to a study that's just been published by The Lancet, one of our nation's leading medical and scientific journals, and it's a study specifically on gun-free zones. Just a little bit of background reading from the study. Most Americans believe that gun-free zones make locations more vulnerable to violent crimes, particularly active shootings. However, the study shows there is no empirical evidence regarding the impact of gun-free zones on protecting locations from violence. The objective of the study was to estimate the association between gun-free zones and active shootings. One more paragraph, and then I'll conclude. Their findings, to summarize, of 150 active shooting cases that they examined, 72 were determined to have occurred in a gun-free zone, so a little bit less than half. And of those 150 control zones where no active shooting occurred, 92 were determined to be gun-free. After accounting for matched pairs, the conditional odds of an active shooting in gun-free establishments were 0.38 times those in non-gun-free zone establishments. They have a 95% confidence level in these findings, and several robust analysis affirmed the findings. And so in conclusion, they say, it is unlikely that gun-free zones attract active shooters. Gun-free zones may be protective against active shooters, in fact. This study challenges the proposition of repealing gun-free zones based on safety concerns. So I've summarized this study for you, and I will send a link to the study, including a PDF, so that you can better analyze it yourself. I think it's an important one for your consideration, particularly considering that gun-free zones are asserted to be soft in some way, and apparently this study proves that they're not, in fact, soft zones. So that's all I want to offer to the committee. I appreciate your attention to this issue, and I'm ready for any questions.
Thank you, Mr. Garrett. Appreciate it. Anything for Mr. Garrett? Okay, thank you very much.
Thank you.
Okay, one final time. Anyone else want to testify on firearms-related issues this evening? Okay, I'm going to close public testimony. Mr. Co-Chairman, how about you lead the discussion real quickly and see where we want to go with this?
Thank you, Mr. Chairman. You know, all this is really informational. At some point, you know, we wrestle with the details, and as I was listening to the conversation thus far today, I was reminded that, you know, Article 1 of the Wyoming State Constitution contains 39 sections. And we're asking perhaps that one of those be subject to local control. And the other 38 constitutional rights guaranteed by Article 1 of the State Constitution would be subject to statewide application. And so this is that difficult issue of gun safety, violence in our modern world, and so forth. But we have this constitutional amendment, and we're wanting to, you know, we're being asked by some of the witnesses to maintain one of those 39 rights as a local control decision. It's a major policy decision for us. Yeah, I did have a conversation with Representative Harrelson a little while ago, and I'll let him talk about what his intentions are in terms of legislation.
So committee, really, I think what it boils down to, as I said, we were asked by the Management Council to take up the issue, and it was added to our ledger. We certainly can do the will of the committee, anything that we want to. I said before, I think in a perfect world, we would rewrite these statutes. We'd give it its own section, and we would do a better job of clarifying what's expected on open carry and concealed carry and whatever. But I don't see that we have that kind of time, and I'm not sure that there's going to be a whole lot of notion to take it up in an interim or to establish a task force to get the work done. I don't know. We'll see what happens going forward. Regarding us trying to draft a bill this fall and go forward with it, I'm kind of cautioned on that front, knowing that we'll probably have more than one of these bills filed by individual legislators. So I'm somewhat reluctant to take this up this fall, not because we don't care about the issue. And by the way, there's nobody in Wyoming, certainly nobody elected in this legislature who is against guns. And to target any one of us based on a vote, whether a bill is good enough or not, has nothing whatsoever to do with that. And so I hope that people will understand, we're just trying to figure out the best way forward, you know, when and where this is gonna hit. But anyway, I'll quit rambling. Further thoughts, committee? Representative Jennings, and then we'll go to Representative Harrelson, okay?
Thank you, Mr. Chairman. I'll try and be brief here. I just, as I've listened to the conversation back and forth, and I think about studies, I think, boy, how important it is that we don't do our governing by studies. There's a constitution, and there's a reason that those things are, they're sacrosanct. There's a reason, and we can change policies on those, but it still has to fall underneath the Constitution. And I think that's important. I listened to Senator Schuler talking to her constituent. And there's differences of how people interpret that. I would tell you he didn't. He still had those God-given rights. He had just been denied those. And that shouldn't be how we govern. We have to look at those things in policy, but in light of our governing documents. And so we should be very, very cautious about trying to put into policy some things that take away those God-given constitutional rights.
Thank you, Mr. Chairman. So obviously, spent a while in the trenches on 125, and this conversation is not new. I appreciate everyone who came and spoke today. Obviously, this is a very multifaceted conversation. We balance a couple things here. One is rights. Obviously, they shall not be infringed upon. That's what our Constitution says here on the state level, on the federal level, and we can have this discussion all day long. I will be personally running a bill again, and I hope it'll be a better bill than last year. That should always be our goal, to hear, to see, to understand what fits best for our state. So I will continue to do that. Obviously, if it's the will of this committee to put a bill forward as well, we can do that. I personally will continue to push this and fight for this, because I do believe this is something that we need to bring forward for this state, and I believe that's something incredibly important to do. So, but I do appreciate the heart of the people as they talk about this, and there's, of course, there's many sides in this conversation, and we'll continue to listen to them and continue to hear them.
Thank you for that, Representative. Good thoughts down on the left side of the dais. Any further thoughts in this regard? Any notions of anything that the committee would want to go forward with? Okay, we're nearing the end. So, Brian, would you like to recap, or do you want to save it for the second day?
Mr. Chairman, may I have 10 seconds?
Absolutely. Senator Case.
Well, it might be longer than 10 seconds, you know how I am. But, Mr. Chairman, on the bill about the restoration of rights, can we put a placeholder in there somewhere? I think one thing we all would agree that we should avoid is perhaps having people from other states come here to get their rights restored based on convictions in their past. I mean, that's not something we want to really encourage. And I don't know, I just putting that out as a placeholder, and I don't know what that means. Maybe you should have to have lived here if there's a conviction in another state, or maybe we just don't go down the route of the other states. But there would definitely be people that would form shop, travel to Wyoming, have a record in another state to be able to take advantage of our liberal laws. And that's something I just want to put on the table. I'm sorry I didn't think of it before.
No, I appreciate it, Senator. That's a good caution. I hadn't thought about that. And I think that we heard from the director that those rights are being restored to former Wyoming residents who were charged in other states and maybe even served time, but then came home. Did I understand that correctly, Brian? I'm looking your direction on that, but I think that was the target of the restoration of rights, was former Wyoming residents.
Well, Mr. Chairman, my understanding, the crux of the discussion was on those convicted of federal offenses primarily. And the question of, federal law prohibits the possession of a firearm, by a felon, and that the confusion that may stem from a person having rights restored with a state law certificate, how that interacts with federal law that still says a felon cannot possess a firearm.
Okay, thank you. Representative Craigo.
So, Mr. Chairman, I think the director was actually talking about both. I mean, I think he was talking about federal crimes, but then we brought up the discussion, or I think Senator Case did, about folks convicted of crimes in other states, because that falls under that subparagraph II, CII, whereas C single I is just Wyoming convictions. the way the statute's written, because it was originally written for voting rights, not firearm rights, you can move here. And the day you move here, if it's been 5 years since your conviction in another state or a federal crime, you can get your voting rights back, I think. And then subparagraph F, which is the one, and thanks to Brian and Katie for pointing that out, and their good work, but it talks about the gun rights, and it references back to C, which is the delineation between Wyoming crimes and non-Wyoming crimes. And so I think if we're gonna split that out, which I'm sure they can do, it's gonna require quite a bit of drafting in that subparagraph F, probably with some subparts. I mean, I think we can, to Senator Case's point, I think we can definitely limit that if we want to just Wyoming crimes, because I think you probably bring up a good point. Or you have some sort of residency requirement before, if it is an out-of-state crime. But I think also we asked the director to talk to ATF and determine whether us granting gun rights back based on convictions in other states, whether we can do that, or whether that also is gonna run afoul of ATF's ruling or decision, not just on federal crimes. And so I think that's a two-step process, and we'll have to find out what ATF says before we make that decision.
That's very well stated, Representative. Thank you. Representative Provenzia, you had something? Okay.
And Mr. Chairman, I'd be
Go ahead, Senator.
fine on the issue of the voting rights. I don't, but the other rights, I think we ought to just take a moment and caution about this. And I'm just throwing it out there so that we don't forget about it for next time.
Yeah. Well, I think it was a good move to work on that piece of legislation a little bit. Appreciated you beginning that conversation, Senator Case, and those who are going to try to work on that. Hopefully we can have a little bit cleaner product when we get here in November. Anything else for the good of the cause, Brian? That,
So, Mr. Chairman, just to go back to that bill draft, the notes that I had was, the bill draft in November would be specific to Wyoming convictions, and I just want to make sure that that is indeed the will of the committee, at least at this point, recognizing that, that language would certainly be within the committee's purview to amend.
That sounds correct to me, and I'm getting heads nodding, so I think we're on track.
And then, Mr. Chairman, if you'd like me to run through today's actions, I can. Otherwise, I'm happy to wait until tomorrow.
I think we can wait till tomorrow. Anything else for the good of the cause, committee? We will see you at 8:30 in the morning. Thanks for the hard work today. We're adjourned. I'm sure.